Earlier also I've given a memo.
Give the memo. Yes.
Signal appeal. That is vigilance. Paper book radio. Because the
But you know the pressure of the board. We'll see. Just give the include that in the weekly list. We'll see. Yes. Yes. No.
item 71. 60.
Let us go by piece by yes.
Item 1 to 4.
Item 4, let's say, kindly taken over next week. Let's say my senior is out of station. Let's say.
Okay. On the request of
Interim
yeah.
content. Let's say.
There is interim order. That's the whole difficulty. You take the then I'll have to look into it.
Let's say my senior.
No, maybe, but you have to see who is your senior.
Mr. DP.
He is senior counsel. Senior on the ground of senior counsel, no adjournment. You can make an alternate arrangement. Now we have given 13 more seniors. You engage anyone. Only on the ground of advocate records you can ask for adjournment. Senior advocate, one senior advocate is not present. You engage another senior advocate. What is this? You take interim order and thereafter you keep on asking adjournment. Further.
Item number 2. In item number 2, the learned counsel who was undergoing radiation because he is suffering from cancer.
Okay.
2 more sessions is required. Your lordship may take it up any day, week.
Okay, Mr. It is stated that counsel for petitioner. Mr. Mahana, the petitioner submits that the counsel will be very the petitioner is suffering from cancer and undergoing treatment and she seeks adjournment. 4 also adjourned for some time.
Item 5.
Last and final opportunity. I'm adjourning it. Last final. Yes.
5 to 19.
Item 5, your lordship.
5. Yes.
File the supplementary copy of the charge sheet. Let it be carried on.
It will come in. We see on request. 5 adjourn. Yes.
Madam, BLA PL number 12,213 by 24. Kindly be listed, my lord.
Give the number.
BLA PL number 12,213 by 24.
Okay, we'll see. Yes, next.
Obviously, my lord.
Item 20 to 32.
Item 32. Let's kindly.
Same adjourn. Entry order is there. We short it. Made clear that item 4 there. It's made clear that no further adjournment shall be granted in the next date of year. Yes.
Item 33 to 42. Item 43 to 50.
Item 50, your lordship, on behalf of Mr. A.K. Chaudhary. Your lordship, since Mr. A.K. Chaudhary is suffering from fever, your lordship, so he cannot be attended before the Hon'Ble Court. The matter will be taken on any other basis.
On behalf of Mr. A.K. Chaudhary, adjournment is sought on the ground of ground that he is not disposed. Please, notice sufficient. Yes.
Item 51 to 57.
Item 53, my lord. A very small correction, my lord. The order date 13/1/25 hour 24
It's only for correction.
That is the correct.
Okay, correction allowed. 53. देखिए correction कर दीजिए.
25.
20.
In place of 24, 25.
Okay. Year 25. Allowed. Okay.
Is 7 Miller. The national college 3 chapter. I have taken the consent, there is no entry model.
Medicine failed.
Medicinal 27.
57. Yes.
58 to 64.
61. 61. Due to my personal difficulty, I played for some time. My medicine is fair.
Personal difficulty. Yes.
Entry model account.
Medicine failed.
Huh?
Medicine failed.
Yes. It is mentioned in the.
Yes.
Item 63, madam. Can you take over 1 week after? Short document, madam.
There is no
63.
entry model.
Yeah, on request. Yes.
65 to 73. 74 to 80. 81 to 86.
Milord 86, I am saying Milord taken up today, Milord. It's a acute Milord appeal and 4 years.
Why are you apprehensive that I will not take it up?
hearing the actually.
Wait, I may come there. Wait.
May I mention out of
Yes.
this lordship? The criminal appeal 308 of 2011 lordships.
20.
Criminal appeal shows that 308 of 2011 lordships has been listed number of times and not been taken up, my lord. Devasis Panda was appearing in the matter, lordship.
You know, the same story in all the appeals. What to do?
It has gone out of list,
Let's
lordship.
see. Including.
308 of 2011.
May I pardon your lordship, two memo for listing your lordship, one release of vehicles and another against 125 CRPC.
Yes, Mr. Mal. Which one? 80? Let it come and put it in this. Yes. Yes.
Item 1,
Yes.
This regarding bail matter, it has come.
It's a bail.
Bail matter.
Yes.
He was all along on bail in the trial. And in the trial, I will say, my lord, with all respect to the trial court is a thoroughly perverse judgment. Here,
No, it's a fresh appeal.
my lord,
Is it a fresh appeal?
fresh.
Fresh appeal.
Appeal of 24, appeal was admitted.
What is the sentence?
There is a 24 or 25 years, man.
What is the sentence?
Yes. The lordship can see the last page of the judgment
No, the appeal has already been admitted.
admitted. It is on the bail. LCR was called for because
Yes.
this
It's for hearing then.
not hearing on bail matter. Bail could not be granted because the LCR was not there.
Okay. What is the sentence about it?
Sentence is about 20 years. Sir. Sentence is let me see.
Huh?
20 years and 4 lakh fine.
25,000 fine.
Undergone? Period of undergone? How much? How much you have undergone?
But after that, I was all along bail during the appeal at the time of judgment. From that date of judgment, around about 1 year now, 10 months. Or
Okay.
Madam, for the respondent informant matter. I filed
all along on
objection
bail.
Your question is not with me.
You should have asked from your public prosecutor.
What are the offenses? 373.
Of-
Now, how this matter has come to me?
It is assigned to your lordship because the Justice Sarpati is related to some other of the.
Okay, specially assigned matter.
Yes, special
Okay. Okay, you have filed objection, you are ready?
objection.
Okay, you get it, I'll give a week after for hearing. Get ready.
But
Get ready, you will see if the
Before that,
appeal has come, we can hear the appeal and finish it
no,
up.
that is why last occasion you also wanted to hear me. That is why I directed to list it as item number 1.
Ah.
Here for nothing, the petitioner is more than around
I
10 years.
understand,
with
I
10
understand,
months
but
time.
the problem is now there is a change of guard. Let him prepare.
But,
Yes. Yes. LCR is there, take the
If
pen drive, you take it.
The
you
matter
get
was
ready.
listed on July. If you would have said so, probably things would have been better.
All right, one more opportunity I'm just giving and get the, take the pen drive and get ready. Huh? Get ready, we'll hear the appeal itself after 2 weeks. Huh? In the miscellaneous list only. I'll wait.
My lord, here I have already filed the objection, my lord.
Get ready with see the time we will spend for bail, we can dispose of the appeal
My
also.
lord.
Exactly, man.
So it's better that we'll hear the appeal and finish it up.
That is the reason for which you also posted today as item
Yes.
number 1.
Yes.
Last occasion.
We'll do.
Last occasion, my landlord didn't
Yes.
say that I don't have anything.
Up, get ready, huh? Get ready, both of you. Yes, next.
item 3,
Your Lordship, I have a question in this matter. This is an application challenge to the non-speaking order dated 30th September 2023.
Yes.
GR case number 7 of 21.
Yes.
By that order, Your Lordship, basically the learned special judge Vigilance Behrampur has refused to discharge the petitioners. And basically, we have also charged the criminal proceedings solely on the ground that the petitioners have no complicity in the matter at all. The background of the case is that the three petitioners are basically engineers who were employed in the Beguniapada block. And
Yes.
in that particular block, as per the Manrega scheme, there was supposed to be a construction of road for promotion of rural connectivity. There were 2 projects basically. One
You are employed as a what?
as an engineer.
Engineer.
2 people, as in petitioner number 1 and petitioner number 3 are assistant engineers, and petitioner number 2 was for the GPTA, junior
Yes.
engineer of
Yes.
Himachal.
Yes, Mr. Marana, what are the allegations?
But your
Without executing work?
Misappropriated and these petition, those petitioner have done the measurement and even implanted measurement figures, check measured by the accident engineer, basing upon that, money has been released.
Work has not been done.
But
You
your-
not even hard it here.
yes,
Extensively.
Hmm.
And they have earlier occasion, council appearing for the petitioner was taking time to show that it on the ground of that funny, but
And
the
it's-
page 106, your lordship can see.
106
No.
of your,
The beginning of in the Punjab district is not covered.
no, your
oh,
lordship.
that I understand.
No, lordship, just one thing, your lordship, okay, we have filed an additional affidavit in that regard to show how Begunia Para
For
block.
all these things on the basis of affidavit, I can't decide a criminal case like this.
But
You
your
file affidavit, whether it is covered by in the funny time or not, Ganjam was affected or not, all these things has to be traced out in the trial itself.
yes, your lordship, I
But
got
the
it.
thing is that the case is instituted on the basis of the direction of the local and they have been given opportunity in the local.
No, we have not been given opportunity, your lordship, and that is on the right submission. No, we have not been given opportunity.
That not required also.
And your lordship, the discharge, in the discharge application we filed, we raised all these issues, but what your lordship, if your lordship comes to page number to see the discharge order,
Yes. So many.
page number 87. The entire, before recording the refusal, the learned special judge only took into consideration the submissions of both parties. And at page number 89, the learned judge only spoke of what section 239 talks about. It has given no reason for not considering the materials on record, your lordship. It is a non-speaking order completely. And in order to support our contentions, we have filed this additional affidavit, which clearly shows at annexure 7 and 8, how Begunia Para block was actually
There is an
devastated
stay,
by funny.
is there any stay operating?
No, your lordship.
Then what is the stage now? What is the stage, madam?
I have to take instructions regarding that.
You must know that, see, this matter is pending from 2023. There is no stay. Charge has already been framed. Discharge application is moved. Charge might have been framed. Trial must be going on.
Framed, your
The
lordship.
trial must be going on.
Charge has been framed.
Trial must be going on. You must tell me
But.
how many witnesses have already been examined and all.
I have instructions.
And his base charge has been framed. He must have claimed that I will bear the trial.
Obviously, that's the reason I.
Now, it's a petition is just by that.
So therefore, I want to know how many witnesses have already been examined.
We'll take instructions.
Pass over and you tell me. I'll dispose it up today. Yes. You also just ask. I'll dispose it. Yes. Next.
Item 6.
6.
Your lordship. Ask of your lordship direction to me. Both parties will present. What thought? If the advocate will so that let notice go so that opposite party will appear, my lord.
You have settled the dispute.
Yes, my lord.
You settled the dispute. Why don't you bring them?
Then
Then you have not settled them.
but let notice go. Otherwise, not can be solved.
You must not be having anything on merit.
Yes.
Let us see where have you said that you have settled the dispute.
Dispute between two brothers, my lord. Let's go to affair.
Sarat Jana and Praful
The
Jana.
name, this
What are the offences?
offense is 419 and 467 and 468. There are two brothers. Difference only his name.
Okay,
Date of birth.
issue notice. Brothers only, yes. Take out, file the requisite and.
Yes, give please.
Item 7.
Okay. Yes. Yes.
Item 8.
Yes. Password. Yes.
Item 9.
Yes.
Here, my lord, petitioner has filed application
Yes, sir.
challenging the dismissal of application filed by the learned court below under 227 discharge
Discharge.
petition. Yes, discharge petition.
Yes.
Discharge petition on the ground that construction work in investigation related to a construction of a CC road and allegations made by the IO that the disproportionate of bill has been passed. Work amounting about 4 lakh some hours and work done within 2 lakhs and another 2 lakhs has been disappropriated by enhancing the bill amounts. Petition is a GPTA. The Gram Panchayat technical officers is the lowest or junior engineer lowest category of or that rank millard, and above that 4 persons are there, chairman, BDO and JE, all are there as millard to supervise all the works millards. And my ground is in the work done in 2011, investigation made in 2014, FIR lodged in 2015, and charge sheet submitted in 2023. Now we are in 2025. Delay in all these things, millards. And I am
Yes.
charge sheet 10 years, how can I attribute it to me?
Inquiry also did not cover it. Your lawsuit is framed as 18.
1/8?
One,
Okay. Yes.
second paragraph.
Yes.
The during construction, fourth pipeline, there are some element administratively approved by the BDO. And since the work was to be executed departmentally, say route, the present study was directed to execute the work and to complete the same within 3 months. As per the case, the work was executed by Route, who recorded the measurement. He also recorded the measurement, prepared the bill, and submitted the bill. On next para, it was assumed the exact quantity of work executed by the actual technical inspection of the project was conducted on ethics committee by the technical local technical so and so the vigilance department. And the petitioners were noticed, but they did not appear.
I'm not there.
Where is that? Where is it?
That is written
Where is it?
prior last line. Prior to the technical inspection, notices were issued to the Devasith Raut and PK Kadam Singh to remain present during technical inspection of talent work, but both of these remain absent during TI and intimated through speed post that there is live list on them and they were getting threatened
Absolutely.
telephonic calls from some unknown persons. These are the and on technical inspection conducted by a team of workers that is found that so,
What to do?
My lord,
What to do? You have not participated.
my lord, what is the difficulty, my lord? I am the new entrant at that time in the service.
Whatever, but these things I can't go into at this stage.
Somebody give it.
Yes.
I know the predicament myself from the site, my lord. But I could not participate in it at the time of investigation also. But what I'm page 36, turning page 36, annexure 4.
36.
36.
Yes.
The statement of IO is some one Narayan Sahu, the last second para.
Yes.
Further, I stated during technical inspection of construction of CC road from Gohakia to so and so, due to non-arrangement of labor for digging the depth, it could not be ascertained the depth of the system. There is a provision of so and so, that what I am humble to say, they are also investigating the spot without taking help of any labor or technical staff, and they have only assessed the upper portion of the roads, the road lying under the earth. They have not taken
all these things. How can I go into all these things at this stage? And you want me to appreciate 161 statement and fall in order? I don't think I think I can't.
The learned code below also the exact
What is the stage now?
has not
What is
been
the
taken
stage?
into.
Charge has
That's
been-
framing of stage of charge, or whether charge has not been framed also because of this.
you better you take liberty and go and argue. Move application. If you have a case, you can.
Yes, my lord.
Then counsel
Problem.
seeks to withdraw this petition to reserving his right to agitate all the points that before the trial court at appropriate date with this liberty, the petition is disposed of. You move application. Yes.
My lord, argue on discharge petitions or on at the stage of trial.
I have given open. I have opened everything. Whatever you want. You move on a discharge application.
My lord,
You move on a discharge application.
discharge I have moved on rejection. I have come here.
Then at this appropriate stage, I have checked.
My lord, my time bound me fixed for conclusion of a trial also.
No,
Because
that's-
I am here
that is a strict this thing.
3 months for
Strict no
because
to
it,
that.
in 10 to 15 years has passed. That is why I am telling you.
I right.
Yes.
Where is that item?
9.
9. Yes, my lord.
FIR was registered when?
Through the 2015.
15. Okay.
15.
The petition further submits that the FIR in the present case was registered on 17/6/2015 and the charge sheet was filed on
So filed on 13/12 to 23.
2023. of 2023, and the trial has not yet been commenced. And he appears that he has been undergoing the rigors of the criminal rigors of the investigation, and the trial since about on the 50 ವರ್ಷ about 12 years, about 12 years. Once he seeks an direction from this court for expediency for the time. Needless to say that the petitioner has a constitutional statutory right of free parent free trial, and hence it is expected that the trial court start to see that the trial is concluded as expeditiously as possible. Yes.
Okay.
Yes.
Then,
Present person is the owner of a motorcycle, my lord. His vehicle has been seized in case under section 20BC of NDPS Act, my lord.
Yes.
And he is not the accused in the alleged case, my lord. He is the bona fide owner, my lord. And his 457 application has been rejected by the learned trial court. I have annexed that annex 1, my lord.
Yes.
Lack jurisdiction, NDPS matter. 457 is not applicable under NDPS. He has to apply
Why?
under that provision. It is region has been assigned at page 11.
Let's see, he is challenging that reasoning
Yes,
only.
yes.
This reasoning is wrong.
That is
He can
That's
get
the-
interim jima. Have you see interim jima? He can get it. It's my judgment.
yes.
Show me that judgment.
Recent judgment, my
Have you
lord,
seen?
held by
Oh.
division bench, my lord. This is division bench by recent judgment by Hon'Ble Justice, Chief Justice, and
Your lordship can.
Have you seen it?
this is 15 1.
Attach a petition.
Yes, my division bench.
Which paragraph, sir?
Paragraph 13, my lord.
13?
13, my lord.
1-3.
Only consideration of last 2 pages, my lord.
13.
Ma'am.
The consideration- And I set aside and send it back.
Ma'am.
I'll
Yes,
set
yes.
aside on the basis of this reference. It was referred
Yes,
to a division bench, and division bench will answer it now. Right now. Petitioner is agreed by the order dated 7/10/2024, whereby his application under section 457 CRPC for release of what is this vehicle? Hero Splendor
My lord.
plus motorcycle has been rejected. It is alleged by the prosecution that the said motorcycle was employed for carrying the contraband, and which contraband and has been apprehended and seized by the police. The petitioner contended that he is not. You are not the accused.
No.
Petitioner is not the accused in the NDPS case, in which the vehicle, the motorcycle has been seized. He pulls up. He is the real owner of the motorcycle. And had moved the application under section 457 CRPC for a release of the vehicle. The trial court by the impugn order has rejected the application. Rejected the application inter alia, stating inter alia observing agent. It is para 5 page 10. Within 404. When was the judgment? The
My lord,
judgment is
the division bench judgment, my lord. It was 15 1, my lord.
huh?
Division bench judgment is 15-1,
15-1.
2025.
This is, recently. Land council for the petitioner has drawn my attention to a recent judgment of the division bench. Past division bench dated
Date was
15/1/2025. 15/1/2025. Passed in Ravindra Kumar, passed in criminal division 503 of 2022 and batch. Ravindra Kumar Behra versus State of Orissa. The exact similar, exact the same question fell for consideration before the division bench, and the division bench, after taking into consideration the taking into consideration various judgment of the Supreme Court and our own High Court has concluded as under para 13, para 13, para 13, 1 point. In view of the law laid down by this court in the judgment in Ravindra so Supra, I'm inclined to allow this petition, set aside the impugn order and remand the matter back to the trial court to decide the application of the petition under section 457 CRPC afresh in the light of judgment of the division bench. With this observation, petition disposed. Yes.
Item 11.
On behalf of Diptiranjan Mahapatra, kindly
Sorry?
1/7. 1/7.
Item 12. Yeah, please.
Yes, sir.
Matter arises out of the private complaints. And there was a NIA case filed in the trial court and the accused there was.
Yes.
What has happened there, one application was filed by the petitioner for payment of interim compensation under section 143A1 of the NIA Act. That the application was allowed. Against that, I have come up with on April 2024. Hon'Ble application laid down the guidelines.
It is not mandatory, you want to say.
Another guidelines your lordship paragraph 19 chotto paragraph
Yes. 19.
paragraph number 19 so
Yes.
flag mark this is
Yes.
that the exchange C the court will have to prima facie evaluate the merits of the case made out by the complainant and the merits of the defense pleaded by the accused, and in the reply to the application, the financial distress of the accused can also be consideration. A direction to pay interim maintenance can be issued only if the complainant takes out the prima facie case. But these things has never been discussed in the impugned order. Lordship will see.
See, the earlier position was also like that. See, if there is a waiver condition, there are two things. One, financial distress and prima facie case. These are the two considerations.
Sir. They would have discussed
These are the statutory incorporation, recent incorporation.
Sir.
And court has now said that the earlier regime of waiver of the pre-deposit, the same principle has to be applied. That's what it says. But the trial court has taken into consideration.
Trial court has only taken the ground that it will, as the conclusion of trial, will take reasonable time under such circumstances in order to achieve the object and purpose of 40.
What is the check amount? What is the check amount?
Check amount is 1 lakh.
1 lakh.
1 lakh. But in the if your lordship will see the complaint petition, he says that it is say 14 lakhs. Your lordship may kindly see.
Show me. No, 14 lakhs. Para 4.
14 lakhs.
No, he has you assured him to return 14 lakhs.
He says that I am a
para 4 and para 5. You read it. Para 4, you have assured to give 14 lakhs, but you have given 1 lakh. That's what he said.
Let's paragraph number.
Deposit 10%. What is the order? 20%.
20%.
Or deposit 10%.
What I beg to submit, because these conditions of the apex court's judgment that has not been complied.
The amount is very less. 10,000.
No, 5 cases. 5 case 40,000 leke 5 case rahi.
10% you pay.
Sir, 20% 40,000.
You tell me. You show me your reply to the statutory notice 138. You have issued the check, no doubt.
Check
Presumption operates against you.
Sayta he apex court cohesion is that presumption can be taken. that presumption cannot be taken. That
Then
is-
see, then you have to see the reply to your notice. Have you replied to the notice under 138 in
Because I filed objection to that, if your lordship will see.
objection? What objection in a complaint case? Show me the statutory reply, reply to the statutory notice.
My lord, if your lordship will see,
That's the first opportunity you got.
well, what has happened, here it is, claim amount is 14 lakhs.
Well, anyway, you pay 10%. I'll reduce it to 10%.
But 10% is also, I see not in a position, lords. Actually, let the.
I'll take 5 lakhs, 10%, 50,000.
40,000 has been awarded. Man, you mean
I am reducing
40,000.
Reducing to 50%. Out of, instead of 20%, I am reducing to 10%. That's the standard order I pass generally.
Let's, your lordship call it tomorrow, I will take instruction and your lordship passed order. Next tomorrow, your lordship.
Why should you wait for your client's instruction? I'll pass the order.
Your lordship only tomorrow.
No. I'll pass it over, ask him. 10%, I'll reduce to 10%, and in all the matters, consistently, that will be followed. By taking into consideration your financial distress. I'll not say anything on privacy.
Your lordship remand that matter on that issue. On financial distress, I have.
See, the problem is remand. See, when the complaint was filed, just
21 only.
21.
21.
Not only 6 months, it should have been over. Now we are in at 25. Why should I remand?
It will be hard and disposed of on merit.
Pass over. Get instruction and just pass it. Yes.
30.
Informant is the assistant sub-inspector of police. One Ramesh Das of Vidyadarpur died of electrocution. The local and the relatives of Ramesh Das blocked the road. I was passing through that road. I got stranded because of the agitation. I have been made an accused. I am no way connected to the village. I do not know who died. I am not at all related to that fellow. I do not belong to that place, my lord. I was passing through. My house is at Chandni Chowk. If you not see, the incident took place at Vidyadarpur. I stayed at Chandni Chowk. From all the way to Chandni Chowk to Vidyadarpur, I will go and stay in Dharna, my lord. And they had blocked the road for the purpose of compensation.
Why had you gone that side?
Sir,
Why?
because I was executing a
You
work.
stay somewhere else. Something is happening. Why had you gone that side?
I'm a builder, my lord. I was executing a work which is beyond that area.
Show me where your work order or
But
something.
the metro.
You have to show. That's the whole difficulty. Why have you gone that side?
Is there any bar in going?
No, not. Then is there any this thing you might have?
There has to be some reasonableness, my lord.
Let us see the
investigate.
Okay, let us see the charge sheet.
Yes.
What does they say about it?
Only omnibus allegation. I found out these local people were involved. I do not belong to that area. It is not my local area.
Where is this incident happened?
No specific allegation.
Vidyadarpur. Vidyadarpur is the place of occurrence.
And if you Rossi see my address is Chandni Chowk, my lord. I stayed Chandni Chowk. I'll go all the way from there and sit at
Fairly speaking, I have no idea the topography of this.
No, sir, your lordship knows everything, my lord. But still then I have to say, my lord, your lordship kindly
What
appreciate.
will amount to scanning of evidence now? All positive
It's
evidence.
not scanning evidence, my lord.
Case has been made out.
Evidence has not been laid.
Now, what is the stage? What is the stage?
So CDTA call for, if your lordship.
Because it's 2009. 19 charge sheet.
Nothing has happened, my lord. Nothing has happened till now.
I'll take.
And you know what is the fate of these kind of cases?
It is from Barang. By next week I'll take instruction.
It is not even 307, nothing. It's
Nothing,
small offenses.
147, 148, 292.
Blocking the road.
Blocking the road. And causing damage to the road.
Issue notice. Let's check it up. Huh? Issue notice. Yeah. Offenses are very small. Nothing serious about it. Yes.
Section 14. May I be formatted on behalf of Mr. Ponda?
Yes.
NBW order dated 3/7/2023.
NBW?
Yes, which is prior to filing of charge sheet, my lord. The charge sheet filed on dated 4/7/2023, my lord.
No, what do you want?
I just want to surrender.
NBW order.
My lord.
3/7/2023.
My lord.
NBW. You are on bail.
No, I am not well, because at that time I am in Gujarat, my lord.
Yes, absconding.
Allegation are yes,
You are absconding, huh?
my lord.
Previously rejected.
Huh?
Three bail applications are rejected.
What are the offenses?
Offences, my lord, initially
304
was
and all.
302, but subsequently it's down to 304 and other offences, my lord. Omnibus in nature, my lord.
15th February, appear. Stay till 15th February. And subject to appearance. Surrender or appeal. Let him appear.
Yes.
15th February. Yes. Before.
Obliged.
Stay till the dispose of.
Disposal, 10%.
10%.
Taken it.
That's a good idea. That's a good idea. Huh? 10%. I'll do it. Yes.
15.
Because see, what will happen is I'll issue notice and he will come, and by that time you spend more than that. Better you pay 10,000 rupees to finish it up. Yes.
May I please?
14?
15. This is a case for quashing of a proceeding. Under section 13 of Odisha Special Court Act.
1 minute, sir.
For it to be not maintainable because he has challenged the passing of the authorized officers of special court. Under the statutory bar under the special court or for it not maintainable. He has to.
That I have to check. That I have to check because.
Take it up.
Because the.
Take it up. This is the preliminary objection. I'll just adjourn it after 2 weeks. Yes.
After 2 weeks.
Yes. Just check it up.
Yes.
Yes.
16.
Yeah. Let us.
Yes, sir.
Yes, challenging the order of cognizance under the for offense under 138 of the NI Act.
138.
My lord.
Yes.
My lord, your lordship.
Who are you accused?
I'm accused, my lord.
Yes.
My lord, your lordship. I'll have a glance to the annexure 1 FIR complaint case, running page 8.
Yes.
My whole contention with your lordship. My lord, first paragraph, brief fact of the case, paragraph 1.
On
That
good
on
faith.
good faith, the accused has taken a friendly loan from the complainant to meet his urgent need, legal necessity for medical care of his wife, and thereby he has issued a check of so and so rupees in favor of the complainant. No date on whose date he has issued, on whose date he has received, nothing, my lord. My lord, my case is, I have taken my lord hand loan of, my lord, with hand loan of, and I paid and give him my lord check a security. My lord, he misutilized my lord and asking me with interest. That is for that reason this is the case, my lord. Because your lordship no, when the my lord attracting my lord 138, he said he should have my lord mentioned on which date he has received money, tendered money. Nothing has been mentioned. Only the my lord, he directly comes to my lord for issuance of the check, and which date I issued the check. That is also not mentioned. On which date I have issued. That is also not mentioned.
Show me the notice. In the notice, it might be written. Show me the notice.
Demand notice. Demand notice. Demand notice टा नहीं मो पाखरे.
That's very important thing.
Check टा खाली अच्छी. I have the copy of the
check. He might not have written it. But
no,
you
he has to mention because in
where is the requirement?
Requirement is malad in 138.
The check number he has written, and he has given a
yes,
pleaders notice dated 26/12/2013.
Malad he cannot malad utilize a check for years together debt. Your lordship knows malad his limitation is 2 years malad.
When the ICC this case was
filed in 2024. And he should have mentioned at least on which date he has tendered money and on which date I had issued the check. That should have been at least he should have mentioned. That is the requirement, my lord.
Everything is written except the date for the check.
That is required, my lord. Because on which date he issued the check, he has tendered money, and the my lord, he cannot issue the check, utilize the check for years together, my lord, back.
Yes, come to page that's 9.
Yeah, my lord.
Para 9. Cause of action. Cause of action.
My lord.
At the top.
cause of action.
Hmm.
Yes. the
Eight, page 8 at the top.
Yes.
Para 9. Read it.
The cause of action for prosecution arose on the date of receipt of the registered pleader.
On 15/9/2023 when the check was issued. What else you need?
Pardon?
The complaint, just see the complaint.
Yes, I'm reading the complaint.
Page 8. At the
Page-
top.
Page 8, my lord.
At the top.
My lord.
Para 9.
My lord.
Cause of action for the complaint.
My lord.
On 15/9/2023 when the check was issued.
My lord.
On 13/12/2023 when the
Presented the
check was
check.
presented before the check court, the bank. On 13/12/2020 when the check was returned.
My lord.
All dates, everything is
That
there.
is, my lord, who is that he has given me, tender me money?
That is the date.
Who is that, my lord? Not on the date of issuance of check.
You,
My lord, he cannot, my lord, humble submission before.
Have I issued the check? You are asking which date? How will I tell?
I'm not
And that those
disputing.
dates are there in the
My lord,
complaint.
I'm
What are
I'm
you
not
asking?
disputing that I have given a check. That I am not disputing, my lord.
What is your case? I have not followed. Where is the statutory bar? He has given the date of issuance of checks, date of dishonor, date on which the notice was issued, and everything is written. What do you want now?
My lord, his very much requirement is that he should have to mention the date upon which he has tendered money. Because that debt is
Not
to be.
necessary.
Yes,
You
my
will
lord,
prove it.
that is requirement on limitation, my lord.
Show me any judgment.
Under
I'll
limitation
not
of 2
ask.
years.
No question of adjournment. Show me the statutory provision.
As per my lord,
That the date of debt is also required to be written in the 138 proceeding.
138, my submission before lordship.
Why are you unnecessary trying?
The requirement, my lord.
Well, show me the requirement. 130. Let us see.
See,
138 NI. The only requirement is the date of the check is to be there. Date of dishonor is to be there. Date of the pleader notice has to be there. Beyond that, nothing is
my
required.
lord, 138, where any person drawn, when it's any check drawn by a person on an account of maintained by him with a banker for payment of any amount of money to another person from out of that account for the discharge in whole or in part of any debt or other liability.
Yes.
So he has to say, my lord,
And
the
he has
liability
said-
of the date
He has said-
because
See,
limited-
read the.
Huh,
He has said that you have taken loan.
my lord.
When the loan is taken and all, these are the honors. He has to prove it in the trial. Let him prove.
Let him, my lord, but he cannot,
He can't
he
prove,
cannot-
then
he cannot-
legally not recoverable.
no, he cannot recover money for, my lord, 5 years, 10 years.
I don't know.
No, that is requirement.
No.
Sometimes 2 years.
That is for section order 37 suit limitation. 3 years limitation. But in 138, the limitation starts when the check is dishonored and notice is given. That's all.
My lord, for years together.
Maybe, but that is for civil suit. If he files a civil suit, you have a very good case. It's barred by limitation unless he discloses when the loan was taken.
Yeah, but here.
But in 138, the limitation within limitation.
My lord, and one thing, when he has given.
There is nothing to debate in this.
No, debate, my lord, he has given, my lord, he has executed my lord, bond.
What is the check amount?
Check amount is his 5 lakhs.
I can only help you if you deposit 20%. Yeah.
Deposit again, move.
Then I dismiss it.
Yeah.
Dismiss it.
Deposit.
I will try only to settle the dispute if you deposit 20% of the check amount as per 143 capital A.
My lord, that.
I can issue notice on that condition. Thereafter I'll try to.
One thing, my lord, whether this can be. See, this is the amount. This is the. See, it is a. Pardon?
What do you want to show?
My lord, front page, my lord, that front page, my lord.
I understand. These are your defenses, sir.
Not only defenses, my lord, it's executed between. And I had given a check on security, and that check he was, my lord, on.
Jafrullah, the best part is you know you don't have a case. That's the best part.
Best part.
Still you are trying.
No, best part is, my lord, it's a case.
Simply, I'll pass some order, then it will be prejudicial to you. Better you withdraw it.
It is I have some my humble submission to Lordship. Without I may not stay order, my Lordship simply issue notice.
No. On that pretext. No, there is nothing. 20 issue notice. There is nothing. No, don't waste time. 20% you deposit, I'll issue notice. And then I explore a possibility of settlement. You will come out of this problem. Subject to
How can I cut?
petitioner
And for
depositing 20% of
when he has taken out 4 lakh rupees,
issue notice to the petitioner, subject to petitioner depositing 20% of check amount. Returnable within 2 weeks. Yes.
he has a 4 lakh ରୁ ପଇସା ନେଇ ସାରିଛି and
Deposit 20%. Yes.
70.
Net income. Yes.
ତଳବଟର proceeding charge. If I will deposit and the proceeding will
A deposit before the trial court, deposit subject to petitioner depositing 20% of the check amount before trial court, issue notice, and the amount to be deposited by the petitioner shall not be disbursed to the complainant. It will not be disbursed. You deposit.
proceeding.
No, I will not say. 138 proceeding can't be said. I will just, once he comes, I'll try to settle the issue.
But
That's
this is
the idea.
apparent mallet, the dispute between the, he has taken 4 lakh.
Why are you wasting time?
and with interest. What is the?
Let us proceed. It is a dismissal case, but I am trying to help you out. Yes.
May it please, your lordship. And the petitioner is challenging the order of cognizance, my lord. Offences are under section 465, 468, 471, 34 of IPC, read with section 82 of Indian Registration Act, my lord. And the allegation is that
yes,
one petitioner number 1 impersonated one Dilip Kumar Mahapatra to issue a power of attorney in favor of petitioner number 4 and petitioner number 6.
Yes.
Further allegation is that the petitioner number 2, who is a co-sharer with the informant, my lord, of a piece of land, he has issued a power of attorney in favor of petition number 6 and petition number 5. And the issue complete is of a civil nature. The informant, petition number 2, and the Dilip Kumar Mahapatra, who is said to be impersonated by.
Let us see the allegation.
That's at page number 16, my lord. It was a complaint case.
Yes. Come to complain, huh?
My lord. Page
No,
number.
charge sheet, just see the charge sheet. Yes. 29, page 29.
My lord.
Yes.
May I read, my?
Yes.
Charge sheet, my lord, second paragraph. During the course of investigation, visited the spot. Spot is the sub-register office Dhenkanal at a distance of 1 kilometer west of from town Dhenkanal. Examined the complainant and witnesses, recorded their statements under 161 CRPC, and seized power of attorney documents by number so and so in the name of Dilip Kumar Mahapatra, and one sale deed document number so and so that Dilip Kumar Mahapatra sold the alleged land to Abhishek Gupta and from district sub-register office Dhenkanal as per the seizure list, and left it in the Jima of Muralidhar Swain, junior clerk of sub-register office Dhenkanal. Verified the land record, but
They sold the land to how many people?
But the complainant could not produce actual land record in this case, my lord. In this case, deliver. And the case is that this particular land, the case of the informant is that petition number 1 impersonated Dilip Kumar Mahapatra. Dilip Kumar Mahapatra is
all these frauds are
my lord,
very apparent.
my lord, Dilip Kumar Mahapatra relating on the same issue, said informant has filed a civil suit that I have annexed. In the civil suit, Dilip Kumar Mahapatra has been examined. He has stated in his examination as well as in cross-examination that I have executed the power of attorney, that he has executed power of attorney, and that the photo on the said power of attorney is also his, my lord.
Oh, cognizance order can't be passed.
My lord, clear, my lord.
By reading the pleading and evidence up in the suit, I will decide the cognizance.
Well, but there is a civil suit, man. The allegations are also purely civil in nature. And in none of the...
Not civil in nature. There is no land.
Well, also in the complaint petition itself, no allegation against all these accused have been...
Forget about the complaint. After investigation, charge sheet has been filed. Charge sheet found the case is made out.
Charge sheet merely says that some documents have been seized. And on the same issue, a civil suit is pending, my lord. There are several decisions that when we...
okay, you argue that on the stage of
my lord, when
charge,
the dispute involved is clearly of civil nature, my lord.
Petition is agreed by the order dated 22/2/2020 13. 2013, now you are challenging.
11 years.
13, passed by the learned SDJM Denkanal in GR case number 1162 of 2023, arising out of Denkanal PS case number 288 of 2009, whereby the cognizance of offences punishable. Where is that order? Where is that order? Cognizance of offences punishable under section 465 or 468 or 471 or 34 IPC. 34 IPC read with section 82 of IR Act 1908 has been taken into court with petitioner. The charge has been framed and everything.
No, charge has not been framed.
Not been framed.
Not been framed.
Sure.
Yes, my lord. Charge has not been framed.
See, and at the next at the belated stage, I mean, after the lapse of about a decade, more than a decade, the petitioner has challenged the cognizance order and states that charge has not yet been framed. Charge has not been framed. If the charge has not yet been framed, then the petitioner has the liberty to urge all the points before the trial court at that stage. Hence, I'm not inclined to entertain this petition. However, you would inclined to change the petition to do all the points before the court below at the appropriate stage. Yes. Yes.
80.
Wait, please, my lord.
Yes.
Because there are three petitions before my lord. They have challenged the order at Annexure 1, order taking cognizance under section 498A, 506, 406, and 34 IPC with section 4 of the DP Act.
Who are you?
Petitioner 1 is the husband, 2 is the mother-in-law,
I'll issue
3 is the
notice.
sister-in-law.
Matrimonial dispute. I'll issue,
My lords.
issue notice to the. What is the stage on the marriage front? What is happening?
My lords, there is no communication, my lords. There are various other matters pending before different forums, my lords.
Settle the dispute. Why? Right.
My lords may stay for the proceedings.
What is the stage after the trial?
My lords, the trial is yet to begin, my lords.
Okay. After 2 weeks, 3 weeks. Yes.
There's an IFS.
Trial has not begun. Why should you file the requisites immediately? We will see. Yes.
Pleasure.
My lord, in this
Yes.
case, petitioner challenge the order of cognizance under Annexure 3, my lord.
3.
3, my lord. Opposite party number 2 is the uncle of the petitioner, my lord. In this case, the arising out
Uncle
of
of
petitioner, my lord.
okay.
They are arising out of civil dispute. There is every chance of possibility of compromise. They are trying to compromise.
No. Petitioner, Mr. Mishra and counsel for the petitioner submits that the petitioner is the nephew of opposite party number 2, and the dispute is arising out of the civil dispute. And there is all probability of settlement, possibility of settlement. Issue notice to opposite party number 2, written reproduction. What is the stage? Cognizance is taken. There is a civil suit pending.
I have filed a IA, my lord.
In the meantime, petitioner is at liberty to move application for the trial court seeking adjournment. Is going to be back at the matter is judicially before this court. Yes.
I have filed a IA.
I have allowed. Move
27,
application.
27, my lord.
Move application. 20 same.
Same.
Same relation.
Same.
Again, then
2 cases are there.
uncle and you. Again.
Yes, my lord.
And petitioner number 2 is another brother. Why are you creating problem for your uncle so much? Then land must be family property.
My lord.
Must be family property. Same. Try and dispute. I have recorded. I'll send it to mediation and because civil suits are pending in the family. What is happening? Yes. Came out. 20. Yes.
21. Challenging the order of the Session Judge Bhadrak, where he has rejected the application of the present petitioner, which was filed under section 408 of CRPC to transfer the GR case from the DMFC Dhamnagar to Bhadrak, my lord. The petitioner is a lady, my lord.
He had filed TP. Your TP is rejected. Huh?
Yes, my lord. My lord, she's a lady, my lord, and having a minor child, my lord, and she is resident from.
What is this complaint case is the what 498 and all?
Yes, my lord.
I'll issue notice.
Yes.
498, yeah, issue notice.
And the miscase is there.
No, you are the complainant. You want stay of your own case. Why are you asking? You are the complainant. Let it go on.
Yes.
If anything happens, you come. Yes.
22. May I please, your lordship? The innocent person has been harassed the behest of the complainant because the entire family member, they were serving in the police department. One is a DSP, another is a sub-inspector and a inspector. They have initiating the proceeding against the present petitioner in a vexatious and false manner. I have annexed 2 FIR.
Before you indulge in all this thing, you didn't know that they are the police people.
They wanted to grab my property because they are, my lord, fencing a boundary wall upon my plot. I am one of the railway employee, my lord. I have objected for that reason because they know that they will not succeed. Rather, they have asserted I have lost the FIR. They have not taken any.
Who are they?
My lord?
Who are they? You have not implemented even.
No, I have implemented the informant. Informants for.
No, you have not implemented.
No, my lord. Sorry. I will implement. Before this on.
You are saying so many things against the complainant. He is not there.
The allegation is
also.
mixing poison in the
Coach.
contaminating the.
My lord, your lordship, I will implement before this on. 2 FIR. I have, for example, I have annexed 2 FIR. Same allegation within 2 days. Where is the chemical examination report? Nothing. Because I am an innocent person, you want to rope me in a malicious proceeding, saying so that I have put something inside the well. For that reason, we are.
Have you got a chemical analysis?
No, I have annexed the charge sheet. My entire charge sheet. Chemical examination report is not there.
And if that is the allegation, unless you have to.
I will take instruction with that regard. But charge sheet has not shown that there is any chemical.
Then your entire allegation is he has put poison in the well.
Yes.
And if you don't get any scientific evidence, how will you prove it?
Yes.
On the basis of 161 statement.
On the
It
basis.
is bound to be acquitted.
Yes.
The poison element has to be brought by what do you call scientific evidence.
Yes.
Check it up, huh? Check it up. I'll just issue notice. Complete.
My lord, because one person, 2 cases, 22 and 23. Same family member, same affair, same allegation, same thing.
Simply issue notice because you have not even implemented the.
No, implement. Just I have.
Complete the information.
Informant as opposite part number 2.
Mr. Das, learned counsel for the petitioner, seeks leave of this court to implement the informant in the present case as the opposite party number 2. Issue notice to newly implemented opposite party number 2. Permission is granted. He may do so during the course of the day and file the amended memo party and issue notice to the newly implemented opposite party. Available within 2 weeks. After 2 weeks, we'll see.
Can I pray before? Pray for the because one of the person is practicing advocate of this bar, and so also his father is old and
who is a lawyer?
My lord, second item, my lord. Devashish Das.
21, huh?
So innocent, my lord. He's
not so innocent. Don't say so innocent. Not so innocent. You move application, huh? Application.
My lord, oblige.
I am aiming at settling the dispute.
My lord.
Because they don't have materials also. Mr. Vishal, get information.
Yes.
If you don't have chemical analysis report, then I don't think that you can prove.
I have annexed the entire document, my lord.
Yes. Need a notice or
urgent copy.
Yes. Next.
24. Can I pray one thing? Can I plead the opposite part number?
No, not here. Everything. Do it during the course of the day. Otherwise, the entire order will be.
Item 24.
No, do it today. You file it there. File it there tomorrow. Today it will go.
Please, my lord. My lord, in this case,
yes, sir.
Challenge order dated 21/12/2024 by the Annexure 1 running page 7.
This is a 138 proceedings. After receiving summons, petitioner appear and the complainant also serve copy, file a time petition for cross examination. My lord, kindly see what type of order passed by the magistrate, my lord.
You are the complainant.
No, I am my lord accused, my lord.
Okay.
ସେ ଓନର ଘର ଭଡା ତାର 5,000 ଟଙ୍କା ବାକି ଅଛି ସେ ଚେକ୍ ଲଗୁଛି ଯେ 2 ଲକ୍ଷ ଟଙ୍କା ଆମର ବାକି ଅଛି
Show me the order.
order dated my lord page 7 my lord the learned counsel for the complainant file hajira PW1 namely Asit Kumar Nanda Vishal complainant is cross examination of PW1 is defer and discharge and for the accused file a petition praying for time had the petition praying for time had the petition rejected accused is represented through 205 CRPC put upon 7/2/2024 for accused statement এটা ফার্স্ট ডেট ଥିଲା ଆମକୁ କପି ଦେଲେ ଆମେ ଟାଇମ ପିଟିସନ ଦେଲୁ ମୋ ଟାଇମ ପିଟିସନ ରିଜେକ୍ଟେଡ କରିଦେଲେ ମତେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ଅପରଚୁନିଟି ନାହିଁ ଡାଇରେକ୍ଟ ପୋଷ୍ଟେଡ ଦି କେସ୍ ଟୁ
You have cross examined PW1.
ମୁଁ ଟାଇମ ପିଟିସନ ଦେଇଥିଲି ମୋ ଆଡଭୋକେଟ ସିରିୟସ ଥିଲା
No, you have already cross examined.
ନାଇଁ ନଟ୍ କ୍ରସ୍
See the order.
ସେ order
Counsel the complaint file hajira.
cross examine the PW1 is defer my lord
Cross examine. Acha deferred. Okay.
deferred my lord
You want to cross examine him.
my lord
Cross. One opportunity is entitled. Entitled. But I have, without issuing notice, I can't do anything.
Your lordship.
Okay, issue notice. Issue notice.
my lord
1 week after law. 1 week. You
My
could file out, immediately file the
my lord
requisites.
tomorrow I will file with
Yes. Yes.
my lord
I'll set aside.
in this case ଅଛି my lord
1 week thereafter I am giving. That is the reason I am giving 1 week.
ସେ ରଖିଛନ୍ତି ଡେଟ୍
No problem. You give it. I'll allow it. I'll set aside and allow.
7/2 କୁ ଅଛି ସରି 7/2/2024
7/2
2024 ଏଇଠି ପ୍ରିଣ୍ଟିଂ ମିଷ୍ଟେକ୍ 25 ହବ 24 ବାଟ
25.
25
7/2 ନା?
my lord if time petition file you an adjournment
I don't need for the petitioner files an application for adjournment to trial court. The same shall be considered. Yes.
ଆମେ
Yes.
ସେଟଲମେଣ୍ଟ କରିଦେବୁ 10,000 ଟଙ୍କା ଦେବୁ ତାଙ୍କୁ ବାକି ଅଛି ଭଡା ସେ କହୁଛନ୍ତି 2 ଲକ୍ଷ ଟଙ୍କା ବାକି ଅଛି ଗୋଟେ ଚେକ୍ ରଖିଥିଲେ ଲେଖିଦେଇକି ଇଏ ଗରିବ ଲୋକ ଘର ଛାଡିକି ଗଲାଣି ତାକୁ 2 ଲକ୍ଷ ଲଗେଇ ଦେଇଛି
ठीक है. Okay. Next.
25, your lordship, may kindly have a glance to page 14.
For 25, I have entered appearance for the opposite party. Let my learned friend serve a copy of the petition. Then take up tomorrow, day after.
What is this?
My lord, here, your lordship, may kindly turn to page 14 for it.
Yes.
My lord, a check was issued of rupees 13 lakhs, which was bounced. And she filed a complaint that 13 lakhs and 26 lakhs be awarded as compensation. Page 14, your lordship.
Yes.
Thereafter, I have paid 13 lakhs in installments during pendency of the case. Then filed a petition under section 258 CRPC to drop the proceeding. The learned court below passed the order under annexure 1, directing me that you pay 3,30,000 as litigation expenses and compensation. But yes, I can very well say.
You paid the check amount on the basis of settlement terms.
No, I sumoto paid the money. There was no settlement.
Okay.
I paid sumoto. That is also the evidence of the complainant that I have received the money, but in installments. I do not dispute that I paid in one shot. No, I have paid in installments.
How much time you have taken?
But I have taken 1.5 years to pay the money.
Yes.
But if I pay compensation of 3,30,000 and litigation expenses, then what is the use that I have paid the money? Malad, yes, interest I am ready to pay.
How much will you pay? You tell me.
Malad, I leave it to your lordship because this is
Take 50% and finish it up.
But 13 lakhs.
See, I'll tell you.
Mara.
Justice Balkishn's judgment, have you read it? If you apply that judgment, then you will get only 15% of the check amount.
Yes.
Because that judgment says that at the stage of complaint stage, if you settle the dispute, 10% or 50%, just check it out.
15%.
15%. And the High Court level, if you do some percentage, in the Supreme Court level, you will do some percentage. So this has been done at the trial court level.
Yes.
So under that judgment, you will get lesser than what.
But here, this is not a question of compromise. After filing of the complaint, the petitioner has deposited the money in
installments.
Now,
they filed an application for the discharge, closure of the case, on the ground that amount has been already been paid. We contested the same, the order has been passed for 3 lakhs and all. Out of 13 lakhs, because your lordship sees the provision.
While accepting the installment, have you protested? Under protest, have you accepted?
No.
Then
that is during pendency of the complaint case.
But we
contested.
You have not accepted without prejudice.
We contested the case of that petition for discharge.
Because it was going on because he was keeping on paying the installment.
Yes.
But without prejudice, if you have accepted, I can understand. Without objection, you have accepted it. So it is ended up in a this is a kind of a compounding case, compounding of a case. But I don't know who has advised him to move application for discharge. He should have moved the application for compounding.
Yes, fine.
He should have moved an application at 320 for compounding. Well, it is compounded. You have paid the money.
Even 15% more out of 13 lakhs.
But forget about it, technicality and all.
Okay.
How much you pay something and finish it up? Unnecessary.
I'm ready to pay.
How much you do? 330. You tell me some amount. Pay and take it.
Lordship, call it tomorrow.
Yes, tomorrow. Ask your client. You pay something and finish.
My lord, I'm ready to pay.
Yes.
But and the wording is, your lordship will see, compensation and litigation.
That is
Don't go by the wording. You pay something and finish it up. I'll quash it and tomorrow. You get instruction, sir. You tell me and so that day after tomorrow. Day after. Yes.
26.
Please be in touch with him. Decided whatever amount you decided. Yes.
26.
Item 26, man. The petitioner prays to set aside or quash the criminal proceeding during 242/23 as filed by the pending as annexed 1 though the opposite party filed the criminal proceeding but not supporting with an affidavit supporting with an verification and also the family court manual act
What are the offenses? What are the offenses?
125 posting
125.
125. Though they have filed minor, but not supported any verification. But the family court rules do the 10 minor institution of proceeding. All proceeding institution before the family court shall be by way of application as per form 1 appended this rule, which should be duly verified by the petitioner
Yes.
That was not done And in the other hand,
this is the complaint. Annexed 1.
Annex 1, and otherwise, the petitioner is the man of the Mahajanpur, voter identity.
I think you have filed an incomplete document.
I am the
Is it a complete document?
No,
filed.
No, they have not filed the incomplete petition,
Why you have not filed the complete petition? See the annexed 1 is not in a complete document.
সেটা যা নোটিসରେ ଆସିଲା ଆମକୁ ଯୋଉଟା ଦେଲେ ଆଉ
ନୋଟିସରେ କମ ଆସିଥିବ ବାକି ପେପର ଗୁଡା ଥିବ
notice
how do you know it is not verified? It may be in the court. You have to go and inspect the other part of the complaint. It is the first page only. The other pages.
Minor complete petition minor annex 1 page 2 page
Did you follow what I am trying to tell you? You have received a summon. In the summon, you got the first page of the complaint. On that basis, you are filing this petition.
No, minor.
Saying that it is not verified.
Minor complete petition.
Where is the complete petition? Just show me in this. You have not filed here. This is not a complete petition. Where is the prayer clause? Complete prayer clause. Show me. Which page?
Prayer minor. It is there for prayer that
no, page.
Page 15 minor. Page 15 minor.
Yes.
So everybody prays for maintenance minor. Who have challenging this minor, they have filed incomplete petition. not supported verification.
Is there, just see page 16.
Pardon?
Page 16, 16.
Page 16, affidavit, only affidavit.
That's right.
No, not verification, my lord.
Oh, forget it.
My lord, rule mat there, my lord. My lord,
Forget about rule.
my lord, your lordship, my lord, come CPC, my lord.
125 proceeding you don't want to pay.
My lord, your lordship, come CPC, my lord. My lord, under 6 rule 15, my lord. Or the verification of pleading, say authorized provided by any.
Sir, it is 125 CRPC proceeding. You don't read pleading procedures.
My lord, no identity, no proper identification is there, man.
No, page 16, just see. What else you need?
My lord, my page,
Read
page 11, man. Your lordship, man, page 11, man.
Page 16, it is very clearly written. I so and so, age about so and so, wife of so and so, address so and so. Do hereby solemnly affirm and state as under that I am the petitioner in the proceeding. The facts above stated are true to my knowledge and everything is said.
No, man. মানে জিতেন্দ্র বেহেরা ও জিতেন্দ্র বেহেরা অ্যাড্রেস এক নিশ্চিন্ত করেন মানে I am the man of minor মহাজনপুর মানে
She might have written a wrong address. That doesn't
মানে maybe approach the technical point raise their tried court minor. The report may be granted minor.
What are you doing for living?
Minor?
What are you doing for living?
That's separately rules. Now,
for earning, what are you doing?
I am a Delhi laborer, man.
After marriage, you become a laborer.
Delhi laborer.
Always that happens. I don't learn counsel for the petition seeks to withdraw this petition to raise all the technical points before the court below. Petition disposed of immediately at prayer. Nothing. Yes. Next. 57. Yes, sir.
So proceeding under 138 NI Act, my lord. Here, my case challenge before this honorable court with regard to the fact your lordship can have a glance to page 20. This complaint petition was filed on 4/9/2024. Thereafter, next page your lordship can have a glance.
Yes.
They, the present complainant along with others, they forcibly entered into my house, took away the some signed documents, forcibly put under threat, signed some documents, and took away those checks along with those documents. I lost the FIR. That FIR was registered. After registration of the FIR, when the case was registered, in order to counterbalance, this has been done. So what I was finding throughout the case, there is every possibility that matter may be resolved.
You should resolve, otherwise you have to face both.
Both the parties maybe, because the first one.
What is the check amount?
Check amount, my lord.
$20 lakhs.
20 lakhs.
20 lakhs. Deposit 20%. Right. Subject to petitioner depositing 20% of the check amount before the court below. Issue notice to opposite party, and the amount to be deposited by the petitioner shall not be disbursed to the complainant. You issue notice, bring them here.
20% instead of 20 lakhs, 10%.
You want to settle 20 lakhs, you have to pay. He will not settle without any payment.
Settlement will be there.
Settlement means what? Settlement means what? You have to pay.
Actual amount what is involved therein, they will get it settled.
2 lakh deposit will not be disbursed.
No, that your lordship indicated, I heard that.
Thereafter will settle the
The only issue is that 4 lakhs would be.
If you are reluctant to pay 2 lakhs, how will you resolve the dispute? I don't know. You want to resolve the dispute?
Yes.
By paying him? You can't, he will not accept at least less than 2 lakhs. 2 lakhs rupees you deposit. And it is settled.
I'm saying that I will deposit 2 lakhs. That is come 10% because 20 lakhs or 20% 4 lakhs. ମୁଁ କହୁଛି 2 ଲକ୍ଷ ଟଙ୍କା deposit କର 2 ଲକ୍ଷ କରିଦେବି
15% subject 15% deposit. Yes, that will be helpful for you only for settlement. And you pay a little more, and I'll disburse that money to him. Finish. Both the cases can be quashed. Yes.
15% here or the
trial court.
Yes, sir.
Trial court. Yes.
And IA that file stay of conduct.
And petitioner move an application Mr. Mahapatra and counsel for the petition submit that the parties are likely to settle these two, this two. Hence, the case for the stay approach on the trial court regarding to the statement made by Mr. Mahapatra, the proceeding before the state, the next day. Yes.
28. Listeners are before not see are a father-in-law, mother-in-law, and the second wife of one of the son of the petitioner, number 1 and 2. Let the prosecution case is that the informant lodged the FIR.
No, petitioner.
Father-in-law, mother-in-law, and the second wife of their first year mother.
I'll issue notice. 490.
Before one thing, your lords, 1 2 initially, FIR marriage was in the year 2010. After she left the house in 2018, it is her FIR.
I'm issuing notice.
The issue notice, order of cognizance, you also want to see.
You don't want that ex parte I will allow. I issue notice and you move application for stay for adjournment, it will be allowed.
I am 494 cognizance charge sheet submitted 494 cognizance.
All right, I understood it, but with ex parte can I allow? So I am issuing notice. That's what I'm saying. I'm issuing notice and move application before trial court for adjournment.
What we are granting since valid charge sheet was submitted against us, only 494 109. Magistrate 2 cognizance, we are granted 41 notice. Thereafter, trial court has issued NBW against us.
So you show me that NBW will see.
My lord.
Where is that?
Against father.
Where is that order?
My lord, running to 36.
36.
36.
Okay.
36 in that order. Father is there. Petition number 1 was there.
Where is it? 36.
36. Running to 36.
Where is NBW?
Order dated 5/4/2024. They appear in the court, file Vakaratnama, and when they are called, advocate file a memo that they want to withdraw the application. Vakaratnama. Accordingly, NBW was issued against
205 has been filed. Yes.
Issue NBW against accused one.
In very first line of the FIR, 490 days there.
NBW 498.
Right.
490.
In the meantime, the NBW issued by the Court of
and against other petitioners 4/5/2024. The Alga date range.
Sambalpur by the order dated 5/4 or 3/4 order.
And order date
3/4.
4/5/2024.
No. 3/4/2024.
The last है 3/4/2024. Running is 36. 36 against petition number 1.
3/4
and last running is 39.
And 39.
Running is 39 he said to Jamapa. Number 2, 3 against 4/5/2020.
Issued against the petition number 1 by the order dated so for submitted order by that so and issued against petition number 2 and 3.
4/5/2024.
2 and 3.
Running is 39.
4/5.
4/5/2024.
4/5/2024. Shall remain state. Yes.
You will have to issue notice.
No issue.
And we'll file a stay for the proceeding or we'll file an application for.
Yes.
29.
May I please, your lords? Lords, petitioner.
What happened 20?
Lords, may I please, your lords?
Yes.
Petitioners, my lord, they challenge this cognizance order dated 22/11/2024 and annexure 5, my lords. And facts of the case is, my lord, petitioners have purchased duplex houses, my lord, from this opposite part number 2, that is one Orchid Jesse, my lord. And what he is doing, my lord, he is virtually, my lord, humiliating and harassing and also forcefully, my lord, collecting money. And when they protest, my lord, disrupting the essential supplies such as, my lord, water.
Where have you said that?
Yes, my lord. Para 5 lords. And you lord say. And when we have gone there to police station to complain against this, my lord, he has abused there inside the police station. Our FIR has been registered first at annexure 3 and his FIR is at annexure 1, my lord.
Yes.
And your lordship will turn to page 16 and the relevant portion is page 18. That FIR, my lord, lodged against the petitioners. They have purchased the houses, my lord. They say, my lord, that with page 18, let's see. They say, my lord,
18.
yes, let's.
Yes.
They say that Abhay Kumar is one of the director opposite part number 2, my lords. Say that director of Sampurna Contact privately being to inform me, we have left out 81 number of houses with purchases. Here, my lord, at the time of handing over units, they for a construction agreement to pay the recurring expenses.
What is the stage of
stage cognizance has been taken? Cognizance has been taken. Only, my lord, page 19, let's see, only he says, my lord, non-payment of recurring deposits. Your lordship kindly turn to page 19. He says it's a counterblast to our FIR. What he says, my lord, last line, we came to know that they have organizedly filed a complaint against us in Airfield Police Station, my lords. Now the fact is, my lord, Annexure 2 series, my lords, page 20 is the brochure, my lords. Brochure, if your lordship will turn to last portion of that page 20, there he says, my lord, this is 5 years free maintenance, my lord. 5 years free maintenance. That apart, my lord, there is also an advertisement at page 23 that this will be the project amenities that not providing, my lords. And when we protest, my lord, what he has said, we had gone there and they say it's a 5 years free maintenance. Page 28 is the sum of the possession letters from 21, my lord. If that is counted, my lord, till 26, my lord, there should be no project maintenance, my lord. What he has done, my lord, page 28, my lords, 28 and 28 with one of the possession letter.
Yeah.
27 and 28, my lords. They say these are all of 21, my lords. 3921. Second one at page 28 is also that.
What is happening?
And page
in a criminal case, my lord, is that to be looked after, my lord? Before the RERA.
No. That leave about criminal.
My lord.
What is this fraud going on?
It is not a fraud.
And if a builder is there, he can do anything. To the innocent buyer, you promised something, you gave something, and today you are saying that basic amenity will not give.
Kindly have glanced the
and file FIRs and all.
Cognizance order, my lord. It's a 506.
I am not on 506, 302. I am not on that. What kind of things are going on?
He must have complained before RERA, my lord. Otherwise, he will file another complaint.
Then they will purchase house. And the developers will give the house promising moon.
Yes.
And thereafter, once they land up in the society, this will happen.
But
and keep on running to RERA, then consumer court, then
my lord,
and thereafter criminal case.
Is my lord only 506 and challenging cognizance, my lord.
That's it. Can we see the page 29?
You call that builder. I'll take care of it. Get issue notice to opposite party, and you have to take care of these people. You can't harass innocent citizens like this.
I have given in a certain memo, my lord. These are the problem, my lord, is.
And your police is mixed up with this builder.
For a moment, my lord. Page 29, my lord. Page 29, Annexure 3, our FIR. We went to the police station at 11:30, but the police lost the FIR at 8:30. At page 29, my lord, our FIR.
If the builder goes, you register the FIR immediately.
Page 32, let's see.
And the victims, those who go to your police station, you don't do anything. This is what exactly.
All the records.
My lord, page 32 for a moment.
Your lordship kindly call for all the records, man. Your lordship kindly call for all the records.
Even CCTV footage is apparent, my lord.
Yes.
Page 32, lordship kindly see for a moment.
Any doubt, my lord, your lordship.
Page 32, lords. Our FIR, my lords.
Yes.
This is why another director, Tribhuvan Prasad, says the same thing, lord. When this and page 33 is important.
Let us treat it as a model case and examine what is happening around Bhubaneswar. Why these developers are creating problem for the innocent home buyers.
Yes, my lord.
Page 33, my lord.
I issue notice, let us see, and get file a status report and ask the senior deputy superintendent of police to file a report. What is happening?
To kindly reflect the order.
Yes. If you notice to the opposite party number 2,
and free copy
also, and regarding head to the allegation made in the petition and government allegation made in the case and the government made in the petition. I'm inclined to direct the deputy superintendent of police. Which area?
My lord.
Which area is this?
Bhubaneswar, my lord.
Bhubaneswar, UP.
No, Bhubaneswar.
DCP.
Yes,
Deputy superintendent. Which area to file a consolidated
ଆପଣ ଫାଇଲ କରିଛନ୍ତି
Bhubaneswar DCP file consideration. He is not made a party, my lord.
Are you making particular?
Taking into consideration the entire allegation, advance the extra copy of the petition will be supplied to the state council. State council in the meantime, proceeding before which court?
Well, that is JMFC Millers that JMFC Millers, one Millers, Bhubaneswar. Flag A, IA is
Flag
A, IA is there.
Proceeding before so is state. Let us examine it as a model case. Let us see how it happens.
My lord, he has to file the affidavit, all the cases, status of all the cases, my lord.
Yes, yes.
What the builder has filed, what the litigant has filed, my lord.
Take a consolidated view. Let us see
My lord.
what is happening.
My
Because
lord.
in the lot of cases are coming in these kind of cases.
My lord.
The home buyers they purchase, and what happens is
If it would be a case of 420, my lord, it is better, but it is a case of
don't
506.
look at technicality.
My
If you go technicality, they may not have a case or they may have a
My
case.
lord.
What is exactly happening is
My
these builders are developing flats or villas, whatever, and they promise everything to them.
My lord.
And after they occupy, the management is taken over by them. And from them, they keep on collecting money. If anybody object, they file a FIR. And the local police is with them, the builders, for a reason you know that. And file an FIR so that there is no, hesitation or there is no protection, protest against them. This is how they harass the innocent people. And maximum people, those who purchase the flat or whatever, they are outsiders. They come for working purpose, they purchase and all. And these people are local people, they keep on harassing. This is what is the story, basic story. Let us take it as an example and find out what exactly is happening around.
So I'm also serving a copy of the difficulties Millers to the learned friend.
You give the entire copy, he will
Yes.
We'll just
Give
take it
to
up.
them.
Yes.
My lord.
I just
by the learned civil judge in division Kujanga. Thereafter, we filed a CRP here, my lord, in before this honorable court. And honorable court passed an interim order that you have filed a time petition before the learned court below, and he has given time. They have not obeyed, they have not considered this order, my lord, this honorable court's order. Now they have proceeded with the matter. 3912 has proceed with the matter. And the matter will be fixed on the day after tomorrow, I think.
3912 is.
And proceed, my suit in the suit, my
your WS has been
the WS forfeited, my lord.
forfeited.
My
It's
lord.
all right, then what will happen?
This court has an interim order, my suit has been stayed, my lord. Interim order passed on
And if
13/11.
this suit is stayed, then how 3912 can be heard?
Well, that's the matter. I have. This is the order, my lord. They have given that if we have filed a time petition, they will consider till disposal of consider our CRP application, my lord. If we have taken adjournment before this learned court below, they have given the time, my lord. They have now our time petition has been rejected, my lord.
There is no stay here, sir.
Alright, time petition. If I have filed before the time petition, they have.
Why do you say that it is stayed?
No, it's not stayed. The matter is tomorrow matter. Please kindly take on any day. Last matter.
Tomorrow. Yes.
Tomorrow matter.
Yes.
Yes. The fresh FAO against the 3912 rejection in a trademark infringement suit. Infringement is continuing. That is the urgency.
What is the product?
Product is a drink.
Huh?
It's a bicarbonated drink. Soft drink. My product has been registered product. And the other side, the respondent's product is not registered. Still 3912 has been rejected. So urgency is its infringement is continuing.
Infringement, 2-3 days infringement continuing, how does it make difference? Anyway, give it the court product.
Tomorrow.
What is the position? Stay? Suit?
Suit written statement has been filed only, and it is for framing of issues.
We'll adjust and beast it. देखिए 2-3 दिन भीतर कर देगा.
Day after tomorrow.
We'll adjust it. It's not very urgent. It is a commercial.
It is urgent because infringement is every day.
Everyday infringement. It's all when the suit was filed.
The rejection is on December 12th December.
Then
and we file.
You allowed this to happen for 1 month together.
Certified copy. Then
anyway, we'll list it. Okay, list it. Ages. Next.
45 withdraw.
45 withdraw. 45 withdraw. Yes.
Item 11 for compromise.
11 compromise.
Compromise matter.
My lord, in this case, my lord, I am appealing for the informant, my lord. An injured person, my lord, the matter has been settled. I have filed the joint affidavit, lordship.
Investigation is on.
Yes, sir.
My lord.
Minor offenses 325,
323.
only 294 is uncompoundable.
Show me the injury report. You have, if you have. What is the injuries?
Injury report.
Tell me what are the injuries? Except FIR, you have not filed anything. What to do?
Aadhaar card
Stage of investigation?
Investigation is continuing. Petitioner is also working as a sub-inspector in a Reserve Police.
Head injury.
Head injury. Injured informant both are present here.
That's right, but what are the offenses? What are the weapon used?
पत्थर छिट देले बोल को
पत्थर छिट
गोटे रास्ता पर पत्थर पड़थले तो गाड़ी छिट देले.
Niranjan Mohanty is
petitioner accused.
Petitioner accused. And
Bonita is the informant and the injured is
who is a police personnel?
Niranjan
Mohanty. What was the allegation? Just see. Yes, sir. Allegation. Or the instance of opposite party number. Who is the informant?
OP number 2.
Oh, the instance of opposite party number 2. FIR number so came to be registered against the petitioner. Allegation is the petitioner. Next for allegation is the petitioner. So. The petitioner number 3 is opposite party number 3 is the injured in the proceedings. Petitioner and opposite party number 2 and 3 are present in the court, being represented by their respective counsel and identified by them. They have also filed their self-attested copies of Aadhaar card to establish their identity. In the present case, the investigation is still going on. The injury sustained by the opposite party number 3 appears to be simple in nature. When the matter stood thus, the parties have entered into a settlement and the petitioner has filed the present petition. Novogishor Vantia Harishchandra. No, Novogishor case. कौन है किला माड़ा कोड़ी किला सेठ क्या सिचुएशन हाँ माड़ा कोड़ी किला हॉस्पिटल रे एडमिट ହେଇଥିଲେ ବର୍ତ୍ତମାନ କାହିଁକି ଆପଣ କେସ୍ କରିବାକୁ ଚାହୁଁନାହାନ୍ତି the parties have filed joint affidavit dated 27/1/2025 inter alia stating as under para 2 to para 6 2 to 6. The opposite party number 3, the injured who is present in the court on query from the court stated that he has received a minor injury in his head and he was never admitted to hospital. They have settled the dispute with the petitioner. Hence, he joins with the petitioner on the prayer for passing the FIR. Mr. Sonko appears for the state and submits that since the parties have settled their dispute and filed affidavit before this court. The nature of allegations are minor. Hence there is no legal impediment in passing the FIR. Regarding that to the aforementioned, and the present case is resulting had to be present and the fact that the parties have settled the dispute, filed the affidavit, subjecting the petitioner to the rigors of the trial, would this time to be futile exercise. Hence, the case of the petition is covered by granting and so on, to be covered by therefore, the petition is merit. Accordingly, the FIR so and so and consequence proceeding arising therefrom, qua the petition is quas subject to petitioner. How much will pay to them? Subject to the petitioner paying rupees 5,000 to the informant and the injured today only 5,000 pay 5,000 ଆପଣ ସିଏ ଦେବେ ଆପଣଙ୍କୁ ନେଇ 5,000 yes yes that is taken yes
Item 33.
Belgium matter my lord, NBW issued my lord 28/2023 my lord. Belgium
फॉर्मेट करती और दो डेट हाँ बेल
NBW issued my lord 28/2023 my lord.
NBW
28/2023
बेल
my lord 22/2021
22/2021 ठीक है ये फॉर्मेट कर दो और तब कर दो 20 फरवरी भीतर एपीआर होगा ठीक है यस 500 हाँ लिख दो 500 local bath, yes.
34.
May I please, your lordship? This is the Belgium matter. The petitioner has released on bail 38/2023 and NBW has been
1 minute 38/2023 NBW
has been issued on dated 19/12/2024.
19/12/2024 okay 500 yes
35.
Oblate.
Now, NBW issued on 22/11/2022, release on bail for 17/4/2017.
Okay 500 yes
36.
NBW has issued 10/12/24. Bail was granted 5/8/2019.
okay 500 yes
37.
37 may I bless you. NBW issued my lordship 27/07/2022 and the bail was granted in 14/7/2016.
500 yes
38.
Obliged, Munshi.
Please, my lords.
Yes.
This is not a bail jump matter, my lords. It is categorized under that list, my lords. Here, my lords, it's a 482 application which I have filed for quashing the order, cancelling the bail granted by this honorable court, and for quashing of the entire prosecution proceeding, my lords. Lordship, the offense was under section 420. The lordship may come to the bail that was passed by this honorable court. Lordship may come to page number 12. What were the conditions stipulated in that, my lords?
Page
12.
Yes. You are informant.
No, my lords. I am the accused. The 420 application, the offense of 422 was filed by the informants, 15 number of them, in which regard there was a bail petition granted by this honorable court and conditions were stipulated, my lords. That is in page number 12.
Yes.
Lordship will see, first point is that the petitioner shall make all efforts to settle the dispute with all the 15 complainants within 6 months from his release. The second condition is not relevant, my lords. It's that he will not leave the jurisdiction.
You make all efforts.
Yes, my lords. Now, the witnesses, 4 of the witnesses appeared in the court below, and they were examined. All of them said that they have amicably settled the matter. They do not want to proceed with the matter. The rest of the informants, they chose not to appear because the matter was already amicably settled. In that light, an order was passed. Your lordship may now come to page number 18, my lords, 18.
Yes.
Lordship, I'm just reading out the relevant portion after 2 lines.
Yes.
They are examined, cross-examined and discharged as PW1, PW2, PW3 and 4 respectively.
The matter has been amicably
Stated that the matter has been amicably settled between them outside the courtroom. They don't want to proceed to the matter. Lingering of the case would not serve any purpose in further improvement of the case. Evidence from the side of prosecution is closed. Then after, my lords, 313 statement of the accused was recorded. It was posted for arguments. Very peculiarly, what has happened, my lords, on the next page, the order has been passed. Accused is present on call. Advocate for the accused files a petition on the ground stated therein. Her time is rejected. Learned APP files a petition under section 311 CRPC stating that PW1 stated that the matter has already been settled between them outside the courtroom, but the accused has not yet submitted any document regarding settlement of dispute with all 15 complainants within 6 months from his release. Thus, the accused person violated the order of the Honorable High Court dated so and so. Well, there is no violation.
You are right, but see, absolutely right. But why don't you pay it to the 15 people?
Malats,
you paid for 4 or 5 people you have paid.
No, Malats. They chose not to appear in the court when the examination were taking place.
Idea
amicably settled. They did not appear for that
you
purpose.
You paid to all the 15.
It has been settled, my lords. It has been settled. They did not appear. Accordingly, an order was, my lords, passed. 313 statement has been recorded.
I understand it. Don't tell further.
Have you
paid it or not? Answer. Have you paid it or not? I'll say it. No problem. But pay it. Finish it up.
Well, let's
don't hide behind the technicality.
No.
The idea is to finish up.
That is not my idea, my lords. The thing is that it's because it has been settled. I do not have any particular instruction in that regard that he has paid or not. But because it was amicably settled,
instruction. See, the condition of the bail is you will make endeavor.
Yes, my lord.
They are not mandatory.
Yes, my lord.
These are not recovery proceedings.
Yes.
And the fact remains that the witnesses have come, they've said that yes, it is settled.
Amicably settled.
And 313 statement is recorded.
Yes.
And the prosecution will take care of its own course, you know. But on that pretext,
now NBW back end of the proceeding, now NBW is being issued, my lords.
Then I'll only cancel the NBW.
I will just intervene, my lord. I am sorry, my lord. My lord,
Mr. Mishra, please. Mr. Mishra, I made up my mind to give relief, and once you intervene, then I'll reject it.
Your lordship put a question whether
you argue or your junior argue.
He is arguing, my lord. I am just informing that he is.
I must tell you that he is arguing better than you. Please hold on. Let him do it. Yeah. What do you want? Then I'll say the NBW. That's all. I issue notice.
Well, the NBW may be quashed, my lords, because there's.
I'll quash it. Even if I quash it, what will be the end result? What do you want?
My lords, the argument may be proceeded, but in my humble opinion, my lords, because it is the order of the London trial court below.
No, the PW1 who has came,
my lords,
and he said that I have taken the money. Even if he comes back, how does it make difference to you? Let him come back. He will tell
PW1. This is the ground taken by the APP in some 311 petition, which
I understand,
which deals with completely different provision.
But he is recalling only PW1.
Malus, that is not what he has stated, Malus. He has stated that under section 3, stating that the PW1 stated that the matter has already been settled between them outside the court, but accused has not yet submitted any documents. That is what the APP has stated in his 311 petition, which again, my lords, is a wrong provision that deals with summoning of material witnesses. 311. He has stated that no document has been.
I'll allow it. Quash the NBW order and let it proceed at its own. Right now. Petitioner is agreed by the order dated 26/12/2024, whereby while allowing the application of the prosecutor under section 311 CRPC seeking recall of PW1, the trial court had issued NBW against the petitioner. And Mr. Mishra, learned counsel for the petitioner, further submits that while the petitioner was enlarged on bail, there is an observation made by this court that within 6 months, within 6 months of his release, on bail, he shall make all efforts to settle the dispute with all the 15.
All the 15.
All the 15 complainants. 15 complainants. He further submits that he has made good he has already settled the dispute with the complainants, and which is apparent from record, apparent from the proceeding dated. You have shown the proceeding, which proceeding? Proceeding dated 21/10/2024. The witnesses, those who appeared before the court, have categorically stated that they have amicably settled the dispute and they have no grievance left against the petitioner. Therefore, the prosecution evidence has been closed and the matter was put for the statement of the accused under section 313. Subsequent to the prosecutor has moved application under section 311 CRPC seeking recall of PW1. On that application, the impugn order dated 26/12/2024 has been passed. I have perused the record and on the perused the record and the order passed by this court in BLAPL number 1322 of 2024. I'm inclined to allow this petition and set aside the order of set aside the impugn order dated 26/12/2024, whereby the NBW against the petitioner has been issued by the trial court, subject to the petitioner appearing before the court and facing the proceeding before the court below. With this observation, the petition is disposed of. Impugn order dated 26/12/2024 to the extent that the NBW issued against the present petitioner has been set aside. Yes.
Grateful minutes.
59.
Yes.
My lord, say matter of Belgium matter, my lord. Petitioner was NBW was issued on 31/9/2015, my lord.
Yes.
And he was granted bail on 5/12/2013.
Please repeat it once again.
NBW issued on 1/9/2015. And he was granted bail on 5/12/2013, my lord.
Okay. NBW is 15, huh?
39.
NBW 15, you see?
Oh. Bell in the nature of Belgium, my lord.
I understand. 2015 is the
Yes, my
NBW.
lord. Yes, my lord.
So you pay
Yes, my lord.
1,000.
Yes.
Local bar. Nuapada. 1,000. Yes.
40.
Yes.
May I please ask matters?
Yes. How many bail applications? Yes.
My lord, victim has already deferred before this court. My lord, kindly cross examination. My lord, victim.
Officer directed to stop the notice because 373 is there. So
That is
that
good.
instruction has not yet come with the notice is sought from the process keep it from other. Order dated no bar issue notice to victim.
You serve.
The instruction are not yet come.
By the order dated 9/12/2024.
My lord, victim.
Direction was issued to serve opposite party number 2 through the IO of the present case.
My lord.
Jenna, Land Council for the State submits that he has not received the instruction as yet regarding the service position. Let him verify the same and place a status report regarding the same. Release the matter after 1 week.
Next week, my lord. Victim has already been intimated, my lord.
Next week only. I'm putting it next week. Next week. Yes.
Date may be fixed, my lord. Victim is contact with the present petitioner's family.
Fixing a date. What is it?
After evidence is perhaps he has settled the dispute.
He's entitled to bail. I'll give after next week. Yes. Let the formality be complete and
statutory.
41.
41 on behalf of Mr. Sahu Merat and pass over.
Pass for it, Aldras. It comes from other demand because your lordship in this case, on the ground of delay that has been dismissed by this honorable court, thereafter review petition is filed. In some cases, that has gone to the Supreme Court and against that order, dismissal order. And as per my record, so there is a order that has been remanded to that. In that case, what happened? I have to take instruction.
No, no.
1 week after.
No. You tell me what is the delay?
Delay is my lord. Either delay basis in 9. But delay ground or say original application that dismissed.
How the review is maintainable?
Maintainable. But say your lordship may kindly see. Is a review petition road next version the page 22.
22.
Man.
Yes.
Original order to that has been remanded for after continuing the delay.
Which original order? This is
that mallet. This is the order mallet on the ground of delay that this honorable court was dismissed the petition FAO. Several cases has been dismissed, and one case that is gone to the issue is same mallet in all cases. Then that was gone to against that order. One case went to Supreme Court. And Supreme Court has remanded. But this remand order is also 2017. Whether that has been dismissed or not, I have not verified.
Yes.
Next week.
And these cases have created a lot of problem in Supreme Court. Hundreds of cases. And many cases are dismissed. And in few cases, what had happened is cost was imposed. Justice Lalit imposed cost of 50,000 rupees. And to only entertain thereafter, again, those matters are also dismissed. I don't know.
What happened?
You file SLP. You get fresh, what you call fresh limitation. I am dismissing it. I am dismissing it. We show dismiss. I have dismissed three petitions. I have dismissed. Tomorrow I am pronouncing. Along with that, I will pronounce this also. Okay. Yes.
No.
But this shouldn't go to the Supreme Court.
They should go to Supreme Court. You get now limitation from today. When tomorrow I dismiss it, you get limitation. I'm dismissing.
Man.
Yes.
Okay.
42.
Yes.
The read were dismissed on 15/7/2022 for non-prosecution matter. And I filed the restoration petition on 16/8/2022.
Restoration contempt petition. Contempt petition.
It's a contempt petition.
You will kindly see arising out of CMAPL, then arising out of
read
item number 43. Sorry.
There is no delay.
1 day delay, technically
Okay.
1 day delay. Because read was
For
dismissed.
the, I'm restoring it. For the reasons stated in the application, the same is allowed. Read petition. Where is that read petition?
Read petition matter 10189 of 2012.
10189 of 2012 is restored to the order dated 15/7/2022 passed by the passed by this court, dismissing the read petition number so and so for non-prosecution is set aside, and the read petition is restored to its original position. This is the read petition for hearing first. Yes.
43.
Yes, sir.
My pleasure. The contempt application has been dismissed for default. I have filed an application for
What contempt? You file a fresh contempt. What contempt?
But fresh contempt, there will be the bar of limitation will be there. You receive 10 days delay only. But in this contempt
already barred.
Notice was also issued. Notice was issued on 13/10/2023. Thereafter, it was listed on 2/8/24. But because of missing the list, I could not appear. And the
Which order is not violated according to you?
But the petitioner was retired on 2009.
No. Which order? Show me the order.
Well, that is in the contempt application. The contempt application is also tagged to this CMAPL. Well, a series of orders. Well, 2009, the petitioner
present petitioner attended superannuation he was retired. Thereafter for service benefits only. There was a direction for regulation of a period and to calculate the pension. That has not been done since 2009. There are a series of writ applications filed, and I have also enclosed all the orders to the contempt application.
File is not.
No, this, see,
And apart from that,
on 13/10/2023, notice was issued. And on the next day, 2/8/2024, it was dismissed.
My lord.
But once contempt petition dismissed, my lord, it's about contempt is the violation of court, sir. So another contempt can lie.
You can initiate a press release.
But you also know there is a limitation, bar of limitation. Within the limitation, I filed the application for contempt.
Here, first contempt, second contempt, everything is entertained here.
No, but 809 in this case, that is not there. Because but since 2009, the petitioner is running from pillar to post. For
Already, see, when you filed it is in 2023.
Yes, yes.
Violation of which order?
Violation of Annexure 4.
Annexure 4 to the petition. Annexure 4 to the.
Annexure 3, 27/4/2022. And page 16 of the 27/4/2022. Thereafter, first contempt, Annexure 4, and this is the second contempt.
I don't think I can do it. You withdraw it and initiate the press proceeding. Right? Petitioner is
these are now since 2009. Person, the retired person, now at the age of 70.
That's right, but you see, first contempt, second contempt, I don't know what kind of contempt are being entered.
But at first contempt, there was again time.
Where from you got that concept of first contempt, second contempt?
Well, that
contempt is a contempt.
Yes, contempt is contempt.
Contempt. The first contempt is dismissed already.
It has not been dismissed. Again, time was granted.
Complying
the order.
First contempt time, representation consideration.
No, not representation. There is a direction, specific direction to regularize a specific period and to calculate the pension of the petitioner. Milord. Till that petitioner is not getting final pensions, although he has already retired from.
Then I will reserve your right to agitate in the right. Better you file a press petition or something. Contempt may not help you. Right on. This is the petition
3 to 4 hours.
Restoration of the contempt petition, which has been dismissed for non-prosecution, by order dated 2/8/2024. Land Council for the petition submits that the contempt petition number 7146 of 2023 is the second contempt being filed by him after the first contempt order, after the extension of time granted by the this court in his first contempt petition number 6866 of 2022. Even after the extension of time, the contemnants have not complied the initial order passed by the tribunal, passed by this court.
This
by the order dated
27/4/2022. In WPC number 6547.
In WP number 6547 of 2022. I'm not inclined to restore the contempt petition. And I'm not inclined to recall the order dated 2/8/2024 as the petitioner has other appropriate remedy available. Hence, the petition is disposed of, but disposal of the present petition shall not preclude the petitioner from resorting to any other remedy available to him.
Your Lordship may grant liberty to file a fresh contempt.
And accordingly, the liberty is also granted to the petitioner to resort to the remedy available.
But I will
either you file a fresh petition or a fresh contempt. Both the things I have given.
A specific order is there.
I know.
They have to comply.
Both the things I have given.
Yes,
now,
yes.
Now you.
If I go for the contempt again, then the limitation period of limitation, that will be a problem for me.
No, Section 14 will be covering you.
The Lordship say
Section 14 will cover it. I said, yes.
For approaching any other forum, wrong forum, but
Yes.
I may be excused, my lord.
I have said that it
Yes,
will not preclude you to.
yes, my lord.
I may be excused, my lord. Item 42. There is a noting as per 42, your lordship is already disposed of. 42, my lord. As per limitation not yet taken, which document number?
Are 1 day limitation, forget
The
it.
limitation petition to file question there.
1 day limitation.
Technicality is there, my lord, because if not filed, my lord.
No, 1 day limitation. 142 on the oral prayer of the petitioner, delay of 1 day in filing the CMAPL is condoned and pass the order. Yes.
44.
There is a delay of 690 days.
Yes. Only.
Only, lordship.
Miss that word only.
No, that,
Yes.
lordship, for a moment. Lordship, I have annexed the document, my lord. The wife of the president initially she is suffering cancer, my lord. She has admitted page 18. For a moment. Page 18.
80.
Page 18 of my CMP.
Let us see the condonation order. That the wife of the petitioner is suffering from cancer and she was treated.
She has admitted and she has.
And she was discharged on 2021. When the matter was disposed of?
The matter was disposed on the 14th 11.
Huh?
14th 11. That is answer 1.
Date, you tell me the date.
14/11/22.
14/11/2022.
Page 8. Now, unfortunately, let's say, give me 1 minute time. Unfortunately, the present petitioner also suffering from some. Well, he has also suffering from cancer. That I have document. I have annexed.
Yes, what do you say? Both the petitioner as well as the wife, both of them are suffering from cancer. That is the reason they could not.
700, around 700 days delay.
690 days.
See the condition. Both of them are suffering.
Both
of them. This is restoration, na? Restoration. Right on. Application, the IL helicopter. The CMA petition is suffering from delay of 700 days.
690 days.
690 days. 690 days. The petitioner removed this application inter alia, explaining the cause for delay. The application para 2, 3 and 4. 2 to 5. 2 to 5. Regarding head to the averment made in the application, I'm satisfied that the petitioner could show the sufficient cause for delay in moving the present application. Hence the conveyance of the application is allowed. Mr. Janna, however, tenuously argued that the inordinate delay of 690 days may not be condoned. The petitioner may have other remedy available to him to educate the issue, the subject issue. You can file a fresh petition also. Anyway, regarding head to the same, the convention is allowed. Consequently, the application for restoration is also allowed. In the writ petition, the writ petition civil number 12733 of 2007 is restored to its own. Okay.
45.
Yes. Honorary visa requisite. Restoration.
This was withdrawn.
Withdraw. Yes.
46.
45 withdraw.
May I please, my lord? Sir, I have filed a modification for order dated offense 13(1)(e) of PC Act. Last date is this the hard order by the vigilance, state vigilance. In my term and consent, the amount of 10 lakhs I have filed to modify the reduction of.
Yes.
Yes, sir.
Huh?
Huh?
Because the data case has been transferred to the PML on the PML Act, transferred to the special court.
Sir, sir, initial this case was registered by the state vigilance. It's ups. And this order has been passed by the state.
No, I understand, but the right party has to be, you know. Where-
Now,
Para?
For 6 and 7 years later, everything has been transferred to the.
Para 6, huh? Where is it say?
Subsequently, this case has been transferred to court.
Yes.
Transferred to the Court of Special CIs from Special Court PML Bhubaneswar on 18th January after the hearing number as also pending for trial.
Then you.
my lord, initially this case was registered by the state vigilance.
I understand it, but now it is transferred. Behind their back,
Now
how can
now the is pending there, sir.
But who is prosecuting you now? PMLA, DA,
Yes,
ED is prosecuting you. Without hearing, how can I release the money? You should have implemented them. State vigilance you have implemented on. Issue notice to the ED, ED written within a week. Advance copy be shared. Give advance copy. Take the order, take that order and give advance copy. And what he says is that 10 lakh rupees he has deposited the bail condition.
No.
I know, even if I give direction, you can't do anything. It has to be released. Technically,
Yes.
I am inclined to allow.
Case of, sir, I am ready to spare my property security.
That's right. I am inclined to allow.
My amounts 10 lakhs. Yes. Not, sir. No.
But what he says is 10 lakh rupees is lying as a bail condition.
And now the
He has
petition is
been
retired
facing the
person.
case from 2009. So he wants a release and he want to substitute. I'll allow it, but let him come. Next week? Next week. He said. Yes.
47.
May I please?
No, then likh diyo. Mr. Maharana, Learned Counsel for the Vigilance submits that the case has already been transferred to the PMLA court. So therefore, vigilance, which is reflecting from para phase para 6 of the petition and as well as the prayer in the petition. Hence, necessary party is the enforcement directorate. Hence, issue notice to enforce. Yes.
May I please? For questioning of FIR, my lord. Lordship must see the FIR. FIR lodged against two persons. One Tushar and another is Shilpa Paharaj. Shilpa Paharaj, the present petitioner, is the daughter of Tushar Paharaj, my lord. The entire allegation.
47?
47, my lord. The entire allegation that received money by Tushar Paharaj, the father of the petitioner, my lord. At that time, she was only 18 years. The land sold, being a co-sharer of that land, the petitioner only signed the sale deed, my lord. Nothing he has been received. The petitioner has received nothing. Every allegation against the against her father that he received, accordingly, an agreement was signed by the father of the petitioner with the complainant. The petitioner is a student, my lord.
A student, but 34 is there.
34 is the, but no allegation is against the petitioner.
But he has signed the sale deed, which is this.
Only that being a co-sharer, he signed. The land belongs to.
What do you say? No, Biswajit Maji.
Yes. I've already filed.
He's already implemented. I issue notice. Let us see. 20-year-old boy, what to do? But he says that he has signed it. He's a co-sharer. Father takes decision. Whose signature?
Okay.
What will happen? This young boy.
Young
Father
girl.
might have done all these things properly. 20-year-old boy, what?
Young girl, man.
All decision might have been taken by the father.
Man.
Unnecessary, being a co-sharer, his signature obtained. What to do? See, you must view in that aspect. Don't go by technicality. If you technicality we go, he may be accused. But just see, I'll just issue notice, let us see.
I also filed the sale agreement, everything I have.
See, if you argue on technicality, you are accused.
No.
I am not on that. I am trying to help you out because you are a 20-year-old boy.
Right.
You are a student. His career at stake. The father,
Not
the
boy.
parents are the cake for property. You know, the parents might have done it. What will he do if the father says sign it? He might have signed it.
Might. Nothing.
Without realizing, this is the reality.
Mild.
This is the reality. Issue notice, let us bring him. We'll try to. What is the stage? Charge sheet has been filed?
Charge sheet has already been filed. So, no interim protection. That your lordship may fix a date. I will
In
take
these
notice.
kinds of cases, the police shouldn't file charge sheet against these kind of 34, invoking 34, you have filed. Anyway, you should.
The 8th.
Okay. Notice by registered postmark.
May I please yours. Last notice was issued to OP number 2.
Service sufficient, sir.
My lord,
Are you appealing?
appealing for the OP number 2? With your lordship's permission, I would like to file my Vatala.
Okay.
And I would also like
Don't
to.
go and take appearance to the party number 2 and seek an adjournment to file the response to the petition. Let him do so. Leave the matter on so and so.
Your lordship, I'd also like to inform that I would also like to inform the court that we have no objection if the FIR is quashed.
You no objection?
No objection. The divorce has, it was a case of mutual divorce.
Already.
It has already been filed and everything has been.
Okay. Better you file affidavit. I'll put it to day after tomorrow. Okay. Day after tomorrow. You file an affidavit so that I'll take into consideration. I'll allow it.
Okay.
49.
Wait, please. The report is there. Part 1.
Yes. Report, huh? Report has come? Report.
Flag 1.
And the report is neither you have appeared nor you have moved any application.
The practical situation you also knows. The practical situation also, there is no evidence. How could I file any evidence that I have surrendered? Everything I have draw your also can intention. I have tried my level best. I have filed the affidavit with the petition with the affidavit. I don't have any other option.
Have you appeared?
You also may extend the date of surrender. I will appear. You also may extend my date of surrender. I will appear.
No, but see what you said is
that is the practical.
What? Now the situation is what exactly is happening is somebody is in bail, already on bail.
Yes.
For his default, NVW is issued in a particular day. He comes to this court. I cancel the NVW. Or I stay the LBW saying that you go and appear. Once he goes and appear, he is already on bail. So the bail should be continued. How can the court take him into custody?
Bail has been cancelled.
Where is the bail cancelled? Bail is not cancelled. He was on bail. For his default in appearance, NVW is issued. Against that NVW, he comes to this court. I say that subject to you appear on such and such day. Execution is stayed. And he went and appears before the court. Then what will happen? Once he appears, then that NBW goes and he is already on bail. He should be released on bail.
Right.
If the court threats, then no, I'll send you to the custody.
And there
What
was
is
no
the
such
remedy
resolution.
for a citizen? You tell me. That's the very unfortunate. That is we pointed out.
In my case, your lordship have remembered,
Huh.
I was in custody for a period of 10
Despite the fact that he is on bail.
in BLA.
For some default, he did not appear. NBW is issued. I passed it. Okay.
4581, I have filed this case.
So how to? I mean, now he says that he is not appeared.
That is there.
Obviously, he is threatened. I'll clarify it.
Yes, Lord.
I'll clarify it
Yes.
rightly. So that in other cases there won't be any problem.
Yes.
Okay.
And the NBW and the date of surrender will also may.
Yes. Right. The matter was taken up for hearing on 17/1/2025 and following order was passed. Pursuant to the aforementioned order, the Sessions Court by its report dated 22/1/2025 has informed this court as follows. As follows. Mr. Maharaja, the counsel for the petitioner, submits that this is a consistent problem being faced by the accused persons pursuant to the orders passed by this court. Despite the fact that the petitioner has been in the regular bail, but for his default in one day NBW was issued. This court by order dated 21/11/2024, although has directed the petitioner to appear before. NBW is for ensuring the presence of an accused. It is a harsh process. Once he appears, that NBW goes. As simple as that. If I say that you go and appear on such and such day, once you appear, that NBW goes. Appear only, surrender before the court. Till then, the NBW issued by the court below, dated 6/3/2019, was directed to be stayed. Needless to say that once the accused appears before the court pursuant to the NBW, either by the order of this court or otherwise, the effect of NBW issued by the court doesn't have any the NBW effect of the order goes. Effect of the order goes. So the obvious conclusion is, if the petitioner is already on bail, he shall be released on bail. He shall be released on bail on his surrender. However, confronting with a peculiar situation, and the present petitioner has moved this application seeking clarification. Accordingly, the clarification application is allowed on the above terms, and the petitioner once appear before the court pursuant to the order of this court dated 21/11/2024, he shall be released on bail. The petitioner is accordingly directed to appear, surrender before the court on or before 20th of February. 20th of February.
Yes.
20th of February.
Fine.
I've clarified. I notified that.
Till then NBW. Till then NBW is.
Till then the execution of NBW issued by the order dated 6/3/2019 is stayed. Yes.
Copy in course of the. May.
Yes.
51.
In one case, when the accused person are in surrender before this trial court, they were in custody in spite the order of this court. For that reason, the advocate could not surrender
Same,
the
same story.
same. In I was filed on CRLMC 4581 in IA about mentioning the region.
Today IA is listed.
I is listed for extension of time oblique the clarification of the order.
Where is this IA? That is
IA
3479. 3479.
3479.
What is your prayer?
Extend oblique.
Extend, I will extend it, but what is the
modification?
Modify the
surrender nahi, they shall be released on bail nahi.
You were on bail.
I was on bail. That was under annex to your lordship may kindly see. Running page.
Yes, petitioner on bail on 22/9/2020. For the reasons stated in the application, for clarification, the same is allowed. Time for surrendering. Time is extended up till 20th of February. February. And counsel for the petitioner further submits that he apprehends that the petitioner may be sent to judicial custody on his surrendering. Although he has already been admitted to bail in the present case by the court below.
By this court, court below by
this court, by this court or court below, who has given bail?
By this court in BLAPL number 3224 of 2020.
Order dated 22/9/2020 in BLAPL number?
No, my lord. As per order of this court, the petitioner was released on bail. 22/9/2020 तला कोर्ट रो bail release हला. BLAPL number 3224 of 20 order dated 38.
Direction is go and surrender. You will be released on.
No, my lord. He was in custody. Subsequently, after this court in custody bail, BLAPL number. And thereafter, he was given the bail bond before the London.
Bail bond when the order was passed.
Order was passed on 3/8/2020.
3/8/2020. And you gave the bail bond on 22/9/2020.
My lord. 3/8/2020.
And was released from the custody by the trial court on 22/9/2022. Needless to say that once he surrenders, the benefit of the order of this court granting the date shall be extended. Yes.
To my lord.
Yes, sir.
My lord, you heard the correction of the GR case year, my lord.
259, 2015.
Yeah, they have the learned code below while granting the certified copy. They have by mistake they have typed out 2015.
In the prayer also you have written.
My lord, because the stamp report will show defect if I will change the year. What has been there in the certified copy. Under Annex 2, Lordship may kindly see page 14. For the learned court below has issued the certified copy. Annex 2, page 14.
2 certified copy?
Annex 2, page 14.
Page 14, okay.
My lord. GR case number 259 of 2015, arising out of PPLPS case number 169/2014.
What is the GR case number?
The GR case has to be 259 of 2014 instead of 15. They have committed a mistake.
How will I correct it now?
I have filed IA, my lord.
You are asking for modification of my order.
Yes.
Order, how can I correct it unless it is corrected? Everywhere you have in the prayer and document, everywhere written 2015.
Yes.
I have to write 2015 only, unless you correct the petition.
Petition, my lord, if I will correct, it is not permissible for me to correct because it is written that.
What is the solution? See, certified copy you have filed, that is 2015.
Yes.
In the entire petition, you have written 2015.
Yes.
I have in the order also, I have written 2015. Now you want that my order should be corrected. Unless you correct your petition, how can I correct my order?
My lord, I have filed one consolidated cost title along with my IA, my lord. reflecting.
In the trial court only you should move application
Hello?
for correcting that. Otherwise, this will be a big problem for you subsequently. Move an application. I'll just adjourn it. You move an application before trial court for correcting this GR number.
GR number.
And get that order. I'll correct it here, isn't it?
Application is now modified.
There you have to move.
Where is to be modified?
Everything has to be modified. But the best way is I'll adjourn it. You move application before trial court, get it corrected, get that copy, and I'll correct here.
That will be.
That is the only one.
Yes,
It has to be corrected from record.
Record, yes.
Record. So I just simply adjourn. You move application there and trial court.
Because Lordship has already disposed of the case, my lord. The NBW is there. Lordship has already disposed of the case. The NBW is there.
I am holding it for two weeks.
My lord.
I am not adjourning it. I mean, disposing it up. I am just simply adjourning up 2 weeks. You move an application before trial court because of the mistake committed by you. The entire thing has happened. Please correct it.
Yes.
Get some order. I'll correct accordingly. So that the entire record is corrected. You move.
Till my lord, Lordship has stayed the NBW till 31st/1/2025. It may be kindly extended for another 2 weeks. So that
otherwise, what I'll do is I'll extend it and dispose it up and giving you liberty to move application before trial.
Yes, that will do.
That's better.
Yes, that will do. That will do.
Mr. Mishra and counsel for the petitioner, submits that the certified copy issued by the trial court, there is a error in the date year of there is error in the error in the year.
Error in the year of the GR case.
In the typographical error in the certified copy issued by the trial court regarding the GR case number.
GR case.
Instead of GR case number 259 of 2014, in the certified copy it is mentioned as GR case number 259 of 2015. 15. Because of the same, error has occurred in the order dated 16/1/2025 passed by this court. I have perused the petition filed by the petitioner, CRMC number 124 of 2025. In the said petition also, the petitioner has mentioned the GR case as 259 of 2015. Mr. Mishra clarifies that Mr. Mishra submits that in view of as in the certified copy, the said number is mentioned, and he had no option rather to repeat the same number in the petition itself. Hence, he submits that he would be moving appropriate application before trial court for correction of the GR case number. GR case number. Liberty is granted to the petitioner to do so. Due to the aforementioned confusion, the petitioner could not surrender before the court as per the direction dated 16/1/2025. Hence, he is seeking extension of time. Regarding to the aforementioned, the petitioner is granted time up till 28th of February. 28th of February 2025 to surrender, and the rest of the order passed, rest of the order dated 16/1/2025 shall remain same.
Till that date, NBW be stayed. Till that date, NBW be stayed.
Till 28th of February 2022, NBW issued by the court below by order dated 11/12/2019 shall remain state. Yes. Move application and get
Yes,
corrected.
yes.
Yes.
Pardon, madam. Item 55, I prefer an adjournment.
Where am I? 54. 55. No, 54. You are 54, na?
52.
52. Acha, you're mentioning. Okay. He thought that I'm saying. Okay, it's all right. Yes. 55.
Adjournment, my lord. Adjournment.
Why agent, sir?
My senior is not, sir.
Must be, interim order must be there.
I don't know, my lord.
Police officer last Friday, ordinary police officer
Same. Your conduct is like that. Somebody goes for registration after fire, you are showing revolver. I'll fire you. And compromise and come and say that I'll compromise. And now another matter. 2015 also, your conduct is, why are you there in the police department? I have asked for a report from SP. Put it, वो matter कब लगा है साथ में लगा.
Number दे दीजिए just after this.
You should be put to task. You can't be allowed to do like this to the citizens. Now he is a DSP or something, yeah? And why don't you take any action? You are the state. You are the state. If he is behaving like this, you take steps. I'll adjourn it and list that along with that.
Pardon to mention.
You give that number so that along with same day.
Pardon to mention, Melo.
Yes.
Item 68.
68?
OP.
Yes, sir.
Will be taken up next week, Melo.
68 adjourn, on request.
My lord, item number 56, my lord. On the last occasion, my lord directed to serve a copy of the brief to my lord state. And today I am serving the copy. Let it be taken next.
Last day I said today.
Yes, because the file was not with me.
Anyway.
So let it be taken next week. I am serving just now the copy of the brief. 56, my lord.
Submits that pursuant to the order dated 56, na?
Again.
Pursuant to the order dated 5/12/2024, he supplied the copy of the petition to the State Council. List the matter out. Yes.
That's it.
Yes.
Item 61. I am for the OP. That's it. I just got information that the petitioner has taken time. That's it. But I have not intimated. Item 61. Interim order.
You are appearing for opposite party. You entered appearance.
We already appeared last occasion. That's it. That's it. Kindly fix it next week, sir. It's an interim order. Due to interim order, mediation failed.
Mediation failed, huh? Mediation
already failed. Since a year back.
This is maintenance.
No. It's 498, 406, and 506 wife.
You are for wife.
Opposite party.
Short date.
Next week, any day, Lord.
Short date, we'll see. Short date.
Lordship, item 64.
Yes.
This case, I have been reallocated the case for Union of India. The Lordship grant me 2 weeks time to take instruction. And Mr. Chan is there. I have taken his consent.
So entered appearance for opposite so the Union of India press and seeks an adjournment. Adjourned. Yes.
Lordship, item 54. Item 54.
54? Yes.
Lordship, file has been transferred. Let Avasmanti and asserted name be deleted.
No, who is appearing for opposite party?
Opposite party.
Huh? Anybody is appearing for opposite party? Wait. Huh? Wait, because see the 54, 55 also same thing happened. Wait, huh? Any mentioning? Okay, thank you. Yes.
Item 7. The 160 case was filed by the opposite party from dishonor of the check. Now, kindly turn to the complaint petition itself.
Yes.
That is under annexure 5, page 17.
Annexure?
Page 17.
Okay.
Here, the petitioner before the lordship was the owner of the bus. He had availed loan from Tata Motor Finance. The bank, Tata Motor Finance has hypothecated the vehicle. Because your lordship know once it's a private, any finance hypothecation is a must. He could not run the vehicle. There, an agreement was entered upon by the present petitioner along with the opposite party to sell the vehicle. That is also his averment in the complaint petition at page 17.
Yes.
My lord, we kindly turn to page 17 for
yes. Yes.
that. May I place it? that the accused is the owner of the vehicle passenger bus bearing such and such, which has been purchased by him, availing loan from Tata Motors Finance, and the complainant was wanting to purchase the same. But once a loan is there and a hypothecation is there, I cannot sell the vehicle. That is admitted. But there was a contract, which is against section 23 of the Indian contract. Thereafter, a check, he could not transfer the vehicle. A check was issued, check bounced. In his statement also, in your lordship at Annex 3, page 20, he has reiterated the same. Paragraph 2, that the accused
Vehicle is with whom?
vehicle is with him. Now question is whether such a debt is a legally enforceable debt or not. There are few judgments on that line. If your lordship permits, I'll place one of the judgments. Here, the case was, my lord, that money was given to X to procure a job in government service. Thereafter, he could not do. He issued a check. That check was put to test.
That is immoral debt.
My case is
Immoral debt is not recoverable.
not, that is my point.
But it is not immoral debt.
Yes, because the hypothecation was there. So once it is a hypothecation was there, my lord, I put the a very agreement between the parties, knowing that there is an hypothecation. The entry in the agreement itself is wrong. And once the entry is wrong, the debt which has incurred is not legally enforceable. That has been also dealt by this judgment.
What you want to say is, if there is a hypothecation and the check, both the things you can't take. You enjoy the hypothecation as well as you are engaged in the check.
One is for that, but 138 cannot be enforceable.
We'll see. Issue notice to opposite party. Bank. Who is the opposite party?
One of the complainant in the court.
And I know. He
was
hypothecated from bank.
He was the person who had entered an agreement with. That is no way important. Bank has no connection.
Okay, issue notice. Meanwhile, you move application before trial court for anything. Yes, move an application before trial court. Why don't you sell it and finish it up? Bank, what is the due amount to the bank?
But the due amount I am paying to the bank. That is not in dispute. Bank has not come up with any proceeding. Question is whether such a debt can be legally enforceable.
We'll examine. Technically, you have a case. Let us see if you can. Absolutely. Yes. Application will file. Yes.
Item 8. That's why day after.
Yes. Yes. Not next week. Yes.
54.
Yes, 54.
File has been transferred.
No, somebody service is complete.
Yes, sir.
When counsel for the petitioner submits that the file from his office has already been transferred and issue notice to petitioner. Nobody has entered appearance. Issue notice to the petitioner. Okay.
58.
These 59 minutes both are connected matter. 58 minutes I am for the father-in-law.
Notice the go.
75-year-old man.
Yes, sir.
You are appearing?
Yes. I'm for
Retired, very senior, respected man, retired English professor in Revenue College. university, now in the university, nowadays also you were there, 25-year-old. And the sad case, family members, there's a divorce case pending, the trial court. And our on merits matters, we can argue on a date that we have also fixed and also particular date in argument. My only point in merit would be subject to further I'll examine. Some of this fatherly is almost bedridden fatherly.
In second matter?
No, first one. Second is the wife.
No, first matter is, yes, second must be. Yes, second must be. Dinesh Kumar Patnaik. Yes.
Laws of the girl must have stayed for only 15 to 16 years. And then she had sporadic stays with her husband who was in Jalandhar.
He's 78-year-old.
This is she's 74. The lady is 74. And these two, and there's a divorce case pending.
I'll just simply adjourn it. Entry order of stay should continue. Yes, continue. Let us see. Time will heal it, I think.
Council appearing for before my appeared. So we made an intent. The girl is pitching too high. Corner soldering is pitching too high. So still these people they tell me now, my young friends.
See, why don't you settle this? See the age of these people.
I understand, my lord. That I have to take instructions.
For a few days you stayed with the husband.
No,
and
but I have stayed for long, at least 3-4 years, my lord. And as far as the compromise is,
You are trying to prosecute your mother-in-law, father-in-law. Those who are in 70s, late 70s and 80s. Why are you doing all these things?
my lord,
You keep on fighting with your husband, no problem.
Today I have filed a wakalatnama.
Keep on fighting, no problem.
Today I have filed a wakalatnama. I will examine, my lord.
That's right, but
whatever I have seen, my lord, the FIR, there is specific allegation against the mother-in-law at least. So that I have to examine, my lord.
Even if there is allegation, see the age. See the age.
5 वर्ष बाद एक क्वेश्चन 2021 FIR फाइल करी तो 16 the last incident happened. Other incidents happened prior to that.
See the age. You have to, see your mother-in-law is 72 years. Father-in-law is 78 years. In 2022. Now there are another 2-3 years.
That I will check.
And you want to take revenge against these old people.
There must be
Because something has gone wrong in your marriage.
I understand the age, but the thing is that she has been a victim, my lord. That is that needs to be considered, my lord.
Now nobody can stop you. You keep on fighting with your husband, no problem. But please leave these old people.
I understand, my lord, but whatever FIR I have read, my lord, there is specific.
I'm giving you 10 days. Either you settle or otherwise quash. This is the two options I'm giving you. I will not go into merits of the case at all. Looking into the age of these old people, those who are at the evening of their life, why are you troubling them?
But my lord, as far as the settlement is concerned, there is a divorce case pending since.
You keep on fighting with your husband. I am allowing you. All the liberties there.
There was a situation when
till you become old, you keep on doing it. Then you will realize what is the.
I understand, my lord. But as far as the settlement is concerned, but I need some more time.
I am giving you only 10 days, not beyond that. I'll quash it.
This particular case, my lord.
Yes. Father-in-law and mother-in-law has to be out. You keep on fighting with your husband.
Give me some more time, my lord, because this case is continuing since 2020.
That is the reason I'm saying.
So, my lord, at least give me.
2022, they filed the petition. That time, the mother-in-law was 72 and the father-in-law was 78.
But the FIR.
We are in 2025. Add 3 more years. 2 more years.
I understand, but
what is this?
But
after 2 weeks, give it. Interim order to continue.
At least 15 days time, my lord.
2 weeks. 2 weeks, 15 days. 15 days.
10 days.
Interim order to continue. And I am making it clear. Tell your client that court has indicated that either you settle your husband or do whatever you want to do. But I am going to quash this. I will not allow the old people to suffer at your end. Very simple. Yes.
I think copy.
Yes. Interim order to continue. Interim order of state continue. Same.
Great, sir.
Yes.
I don't want to mention item 55. Appointment.
55?
55.
Opposite party appearance level.
For OP number 2.
Yes, yes.
Mr. PC.
Yes. 60.
Item 55, but that connected matter needs to come on 30.
Let it come.
60.
Yes.
The rejection of an application for this. The case was disputed against the petitioner. And prosecution has included the assets of son and daughter. If those assets are excluded, there will be no. On the other day, I have submitted a proceeding that they both the sons and daughters were studying the Bola Medical College. During their study, they have received about 16 lakhs plus their stipend, etc. And these two bank accounts stands in there. You also may kindly come to the statement of they have collected that information. Page 169. Page 69.
69, yes.
That is the account structure of the Bulla Medical College.
Yes.
And fourth paragraph you also found. Dr. Swatilina Pradhan took admission in India's Teacher Course Department of Skin and Beauty on 9/8/2012. She had been paid total stipend amount of 75,418 during the period from Ishwar. Similarly, Dr. Sobrajan Pradhan had taken admission in three-year PG course Department of General.
16,90,000.
Right.
Yes.
Now you are also going to charge sheet.
Yes.
Page 59.
Yes. Yes.
First two bank accounts stands in the Sobrajan Pradhan 7,74,000, and second one is Swatilina Pradhan 8,31,000. As I can compare what amount they have received and what is the
12 lakhs, 16 lakhs. Yes.
as against 12 lakhs. The balance stands in name of Swatilina is 8 lakhs.
8 lakhs. Yes.
And as against Sobra's account, he has received 60 lakhs 9,000. As against that, there is a balance of 7.74 lakhs. These two accounts have been included just to make out a case against the petitioner. If those two accounts are excluded because of their property, they are not the active persons. Their property can be included in the charge sheet. They are the active person, they are not facing that.
If that amount is taken off, what will be the?
That will be no DA. Very marginal amount. Very marginal.
When 7 lakhs, 7 lakhs and 8 lakhs.
8 lakhs.
Okay.
Total.
About 15 lakhs.
Total amount. Yes.
Suppose about 15 lakhs is taken out.
Yes.
What is the disproportionate according to you? 29 lakhs.
The 10% would be 12,79,000. It is slightly more 13,86,000.
23.41%.
About
Allegation.
80,000 or something. Because below 10% it will be more.
Yes. No, 23.41% is the DA according to them.
Now, presently.
Minus if 15 lakhs is roughly taken out, then it will come down below 10%. Yes.
The other day, my government submitted that they need to produce some document. The daughter and son is concerned. Their income expenditure that has not been taken into consideration. Whatever the PG amount they have obtained by your stipend, they have spent. And how can you say? I am saying from your statement. And both the petitioners in writing, it's a case initiated on the basis of the inquiry conducted by the Lokaika and thereafter inquiry transferred to the Vigilance Department. And on search, we did not find a single document related to bank account. And 27 accounts were seized subsequently. We collected. And so far as the son and daughter is concerned, both the petitioner given in writing, they have not given us a single part. Rather, we have made deposit, we have spent money for them, and they are residing separately, their income and assets will not be taken into consideration. Considering their written submission, and we have not taken into consideration the incomes received by them by your stipend. Because income received by them by your stipend, they have spent it, because the daughter is concerned, during the period of stipend, she got married and she was residing in a in-laws house. So this income, her income and assets expenditure, nothing was taken into consideration. So for the son is concerned, son has out of those two accounts, the deposits. Your lordship last occasion asked me to produce the documents, so whether deposits, who has made the deposit? All the monies have been deposited by the petitioner. Is it the
Whether the question is whether it is stipend money or these people have done it.
they have money is concerned, I have other aspect also. Your lordship can see my objection. The stipend son is concerned. Your lordship can see below the money has been.
Who is Jyotsna Rani Pradhan?
Mother.
You have deposited
Everything has been deposited by the mother.
30,000.
And another. Then another aspect is, and the money has been deposited in the accounts of the fund when he was not getting any stipend because he was at that point of time he was an MBBS student. So there was no question of consideration of his stipend does not direct.
Those documents that are part of the CS, then let me.
It is part of the CS. Can you go through? It is because to obtain on by certificate of you have obtained from the report.
You have been depositing cash in their account.
Let me verify whether that is correct or not, because I have.
You certificate copy is given.
No, that doesn't form part of this charge. That is why I am asking for it.
Where from they'll get the charge? They have got.
Because how can you tell like that? It's not expected. Because I say, because that is not cited document in the charge sheet. And that is why I said, and it been there with you, you would have not charged.
Cash you have deposited in the account of. These are the certificate copies.
Copy of it so that I can verify. No, it is not. It's not mentioned in the charge sheet. Everything.
The entire charge sheet might have been supplied to you. There, these vouchers must be there.
It is not there. Can see the statement of Father. It is not there. It is not mentioned in the charge sheet.
You don't have a case. You verify that. You have also said the statement is also very. You verified. Give a copy to him. Verify. Nothing is there. And Mr. Maharana, the Council for the Business, hands up for couple of vouchers popular deposit slips. And submits that the accused number 2 has deposited cash in the bank account of their son and daughter repeatedly. The counsel of the petition submits that these are the documents not form part of the charge sheet and seek adjournment to verify the same. Release the matter.
It's not a document.
Just check it up. It must be certificate copy. He got it. Certified copy from the court. They filed it and certified copy to court. That must be a court part of the court record. Anyway, for your satisfaction, you do it. If that is not there in the court record, where from they'll get it? Yes. Anyway, adjourn. Yes. Next. No, no, last time I have not given you. No, I am not satisfied. I would have disposed of today. But since you are asking, I am giving. Where is the question? Not putting some document. It is the charge sheet, part of the charge sheet.
It is not.
How can you doubt a certificate copy obtained from the court record?
Not there. Let's ask it on point.
So next item. Next item.
62.
Yes, 62. Yes.
Yes, my lord. I'm appearing through VC, my lord, and for the petitioner in item number 62.
Yes.
My lords, in this criminal writ, petition, we have challenged the order passed by the learned court below, dated 5th of April 2024, by which order the petition filed by the petitioner under section 254(2) CRPC to send the questionable checks. This is a case under section 138 NI, to send the disputed checks to the FSL for handwriting, for opinion of handwriting expert and forensic science opinion over the aging of the ink. That petition was rejected, my lords. We are against that petition. We are against that order. Now, time and again, questions has popped up that sending a checks to FSL will consume more than sufficient time, and it will protect the trial, my lords. I would not deny that. So in that view of the matter, I am relying on the the judgment of the Honorable Apex Court passed in Manorama Naik versus State of Odisha and others, criminal appeal number 432 of 2022, special SLP criminal 9722 of 2016, and other matters, other judgments such as Murari Lal versus State of UP, 1980 SEC criminal 330, Lalit Popli versus Canara Bank and others, 2003 3 SEC 583, wherein the Honorable Apex Court has clearly.
Where are those judgments? Please give the copy of judgment.
I'm citing these citations. Let me submit. I'll submit those judgment, my lords, before your lordship, wherein it says that that apart the signature and handwriting.
But you can't. Please, Mr. Ansari, you please give the judgment copy. So how will I relax? Shall I?
This is the first time we are taking up the hearing. So I'll submit the citation, my lords. I'm just citing it today. So
do you have any briefing counsel here who can supply the copy?
No. I don't have anyone there, my lords.
Then you file those documents which you want to rely judgments.
I'll file the citation by tomorrow, my lords, and the matter may kindly be disposed of in accordance to the.
Counsel for the petitioner wants to place on record the relied upon judgment. These the matter. Yes.
Also short adjournment, my lords.
You already filed. Yes, that I have seen it.
A short adjournment, my lords.
Written submission filed by the opposite side. Have you got the copy?
No, my lords. No copy has been served upon me.
That the written objection filed by the opposite copy of written submission supplied by the filed by the opposite party has not been supplied to him. Counsel for the petition undertakes to supply the copy of the written objection.
My lords, a short adjournment within maybe next week, my lords.
Yes. After 2 weeks. Yes, next.
Much obliged, my lords.
Copy, please. अरे जेरस कॉपी उठ दे दियो तो कौन है तारो? Yes, 66, 65.
65.
Urgent, no, yes, yes.
66.
Refer tomorrow, man.
Not tomorrow. Yes. Okay. Urgent. Opposite party appeals on behalf of the petitioner, adjournment is sought. 66.
I prefer tomorrow night.
No, tomorrow can't be possible. Can't. No, why? What is this case is about? I can't adjust the board like this. It is very easy for you to tell tomorrow. Lot of work in the registry has to take place. The file has to go again, list the matter, and so many things takes place, and the entire board is disturbed. Let us see what is this matter. Judgment is required or not required. Let us see. What is this case? Case is matter. NIA.
No, not NIA. Did win a case on NIA and I have no case. But their case is that case of the opposite party is that minor that I will be took from them about 20 lakhs rupees and I repaid 15 lakhs rupees. 5 lakh rupees remain outstanding money. Then again, they say I took 2 lakhs rupees again. So all total 7 lakhs. 7 lakhs rupees I issued checks. Those checks in the complaint petition they say that we came to know that such account doesn't exist or no money is there in their account. They deposited the check in the bank, got it degenerate, but they did not file issued notice, but they did not file any case on section 138 of the NIR.
Yes.
Subsequently, they filed a case and cognizance was taken on section 417, 418, 419.
Yes. What are the allegations? Let us see.
Allegation. Then, my lord, my respectful submission from my lord, the basic, the crux of the case is the issuance of the check, which they got it degenerate. So they
Not got it degenerate, it got degenerate. On your account, there is no money.
Yes.
They didn't go to the bank and say that degenerate. Because you had no balance there, for it is degenerate. And they have not prosecuted you under 138.
Yes.
Is there any bar that they can't prosecute you otherwise? You should be happy that 2 cases would have gone against you. Now only you are facing 1 case. You be happy with that.
The offences of those of which cognizance were taken, my lord, those offences were not made out at all against.
That is a different story. You satisfy me on that.
So far 420 is concerned, my lord. 420 is a cheating. So a person getting a check, he should have the intention from the very beginning not to give the amount, the check amount to the complainant, my lord.
Yes.
But here, I have already paid the 15 lakhs rupees, my lord. So therefore, 420 cheating for intention of the petitioner's, my lord. That is not borne out from the record, my lord. Because I had no intention at any point of time to cheat the opposite part, my lord. Then, my lord, so far as the 419 is concerned, that is impersonation. Their case, my lord, may kind. But
the fact remains that you have taken 7 lakh rupees. Why don't you pay it? Forget about it.
The complete petition is.
You admit yourself that you have taken 7 lakh.
That is their case.
What is your case? How much you have taken? Come, simply you tell, don't go by all these things. How much you have paid, taken?
No, I have taken
Come to that point. Forget about 420 and all. I just ignore that. How much you have taken, how much you are going to pay? Simply tell me. You admit yourself that you have taken.
That is the case I was telling.
My London Senior first interest starts that there is
He said 7 lakhs. He said that.
There no interest.
Now you come and pay the money and finish it up. I will fix the installment.
I presented the case.
Nothing doing. You pay, deposit the money. At least 2 lakh rupees deposit. I'll send it to mediation and finish it up.
That's 417, 18, 19, 24, 24, 16.
Then keep. Okay, then keep on fighting. And keep on fighting. What is the use of it?
Then the petition.
You deposit 2 lakh rupees. I am sending it to mediation and finish it up. What instruction? No, I am giving a direction. What instruction? Why should I am giving? Huh? Then I'll reject the judgment. I'll pass.
So what is it, that 67, 68, which document I forged? I showed that.
I'll just see. It is only cognizance. Cognizance is taken, nothing else.
That is the proceeding.
Cognizance is taken and 202 statement, come to 202 statement. And come to the complaint. And by reading these things, cognizance is rightly taken.
Yes. Hold on it. Not a single offense is made out. In my entire career, so
Why are you bringing entire career into it? You have taken the money, pay it. As simple as that.
Again, that will be decided at the time. Whether they have taken.
Or then face the trial and keep on proving it. Come with instruction tomorrow. How much you will pay? Just now you were asking time for tomorrow only. Now I am giving right now that come with instruction. How much you will pay? No, I am giving a day after tomorrow. You come with instruction. Come with instruction. You pay it, finish it up. See, if not 7 lakh rupees, you might have taken some money. Whatever, I'll send it to mediation, deposit some money, and sort it out. Day after tomorrow. Come with instruction. ठीक है. Okay, it's all right. Okay, Thursday. Shall I pass an order that all of your matter will be listed on Thursday only? Okay. Tuesday. And tomorrow then? Tuesday is tomorrow. You are getting cut by your own this thing. Tomorrow then?
Tomorrow.
Which is the best day to communicate? ମୁଁ କେବେ ବିରକ୍ତ ହୁଏନି ଚିନ୍ତା କରନ୍ତୁ କାଲି
ମତେ 64 ଲାଗେ ମୁଁ କେବେ ମିଛ କଥା କହିଲେ କୋର୍ଟ ମିସଲିଡ୍ ହେଇନି ତେଣୁ ଆପଣ ବିରକ୍ତ ରହିଲେ କାଲି ରଖନ୍ତୁ
ମୁଁ ବିରକ୍ତ କେବେ ହୁଏନି ଠିକ ଅଛି କାଲି ଠିକ ଅଛି ନହେଲେ ଗୁରୁବାର ରଖିବା ଗୁରୁବାର ଠିକ ଅଛି इंस्ट्रक्शन नहीं क्या सुन ठीक है गुरुवार इंस्ट्रक्शन नहीं क्या सुन तू केते पैसा दवा देबे ठीक है जी ओके
67
This is the application for flushing of the affair.
Notice was issued, but no one had the information.
Notice was issued. This service देखो तो. Let us see service please.
21/11/2024.
On the basis of a written content of
1 minute. Let us see service position. Submission. Yes.
On the basis of the written content of operating partner of this case, that is the Bhadrak Town case number 396 of 2021 corresponding to JFX number 2706 of 2021 has been instituted on section 341, 323.
I'll ask the IO to serve once again because these are complaint. You have implemented the complainant. Yes. Despite service on opposite party number 2, none appears for the opposite party number 2 in the interest of justice. The opposite party number 2 should be served through the IO of the case. IO of the case. List it. Once again, we'll make an attempt. Yes.
69
किए मेंशन करो that's the problem.
The last order was directed that appear to after appearance it should be reported in the
as old friends and it is expected the petitioner may settle the dispute. Who is he?
I say that they have received, they have got the money from me, they say that they have given money to me. So this is a case and counter claim between the parties.
But
And now they have come forward with an FIR saying that bribe money has been given.
so what to do now? Shall I put it next week? Next week, entry mode to continue. You tell your friend who is appearing. At least he should have intimated you.
In fact, my problem is I am not there, so I have before loss, I could not come.
But he should have intimated your office at least. Yes.
69.
Yes, sir.
As per the lordship direction, active person had appeared before the IO and cooperate with the investigation. And the state is different.
With regard to, we obtained the instruction.
Yes. What are you seeking here?
I'm telling for council of residential.
Huh?
Council of residential.
Duplicate जो engine oil सब तैयार करते हैं सीधा सीज रेड है कि जरा.
So what is he asking?
Whether they have been appearing before the IO on the day-to-day basis. That was the last time your lordship saw. And IO gave instruction that they have appeared and cooperate with you.
So what, it's all right. Now what to do? You have cooperated. It's all right. He has said that. Now, what exactly you want?
Praying for the house is sale and the present petitioner is a senior citizen person and the present petitioner is the co-accused. The principal accused is the son of the present petitioner. The principal accused has selling automobile product, which has the GST certificate at the Annex 3.
Come to your prayer first. Page 9. Direction to effect that unseal the residential house of so and so pending in the court of JMFC so and so.
Yes, sir.
For unsealing.
Yes, sir.
Investigation is still going on?
The charge sheet has already been filed. And the
No, charge sheet has not been filed.
Yes, now charge sheet has been filed.
Yes.
Charge sheet has been filed when?
No, the charge sheet has not filed.
The charge sheet is not where you see charge sheet is filed. You see? It only says that these people have appeared and cooperated. That's all.
I don't have to into one thing. The alleged offense under the FIR.
1 minute. What you are seeking quashing of the entire thing?
No.
Then
I am only paying for unseal of residence.
until you have to move the application before trial court.
Yes.
Not 482 petition. And investigation is still going on. Therefore, I wanted to know it.
Yes.
Charge sheet has been filed or not?
No. As for the instruction of the
pursuant to the order dated 7/1/2025, the IIC IO, who is
IIC Tiptol
has filed a report entry stating that the petitioner and other accused persons have cooperated with the investigation. However, it is not disclosed as to whether the charge sheet has already been filed or not. Therefore, the Mr. Biswal and Counsel for the State seeks an adjournment to obtain instruction regarding the same, lease the matter on so on. Yes.
70.
My lordship, on behalf of Senior Counsel Mr. Gopal Agrawal, I kindly seek for an adjournment, as Mr. Agrawal had some personal difficulty.
Where is he?
He had some personal difficulty to come to the court today, my lordship.
What is this matter?
The discharge order, sir. The initial dictate was registered by the state vigilance. Subsequently, it has been transferred to ED. During the
Which has been turned down.
last occasion, the court has passed to notice
No, after 2 weeks, Agrawal is not there for
the
hearing.
matter.
In his absence can't be because ED cases has to be heard.
Because client is
Short date
not-
I'm giving it. I'm giving a short date. I'm giving a short date. Yes. FAO, what is this FAOs? Chattakhand FAO chief. I know, but he's not there. Personal difficulties in that way. Yes. Yes. Yeah, FAO is a code over FAO. Sorry, sir.
In this case, I am challenging 2 points.
Let him come. I can't hear him. He's absent. Yes. But no further adjournment will be given. There is an opposition. Yes. Yes.
I
What do
have
you
one
say, sir?
item 73, my lord.
Yes.
In the WC Act, if you will, the EC Act, it can be.
Hmm.
The ground of the vehicle, no, pending vehicle, no permits. Instead of our against which against the owner, our application is transformed. So, because lordship, dispose of.
The amount.
Recover the amount from the owner.
You record that right is there. I'll just.
Milord, what happened, Milord? I am passing a similar past by the line of justice.
That right is always there.
No,
Right to recover is always there.
No, Milord, we have settled this. We have settled the quantum, Milord. We have amicably settled the quantum. Without recording our concession, your lordship can dispose of it by this manner, Milord.
Yes.
Here, Milord, we have settled the amount at 10 lakh 50.
Yes.
Here the awarded amount was consolidated amount. Awarded amount was 12 lakhs 97,600. We settled 12 lakhs 97,600.
97,600.
600. Okay. Including interest. That is the including interest, principal and interest. We have settled it at 10 lakhs 50 consolidated. They have deposited the entire awarded amount before the commissioner.
Okay, I'll dispose it.
Yes. So far, yes. All grounds. Milord, so far the right of recovery part is concerned, what he is submitting, Milord, my friend is submitting, Milord. By virtue of our High Court full bench judgment under 2006 OLR Volume 1, page 715, National Insurance Company Limited versus Panibudi Chulia. 149 is not attracted for the WC Act, EC Act, Milord. But they have the liberty to recover it from by approaching the common law forum.
That's the settled position.
Yes, that is the settlement. In these proceedings, they cannot do it.
Obviously,
yes,
they have to file a recovery suit. Whatever they want to do, common law, they will.
Yes, come. That liberty your lordship may grant. That liberty your lordship may allow.
Right, right.
Take it up.
I heard Mr. So-and-so. the present appeal is arising out of is directed against the where is that order?
EC case number 26.
Order, where is that order?
Order annexure. Appeal motion.
Directed against the
Order dated 31/7/2024.
judgment dated 31/7/2024
Order
passed
EC
by
case.
the Commissioner cum Employees Compensation cum Division Labor Commissioner so the by the impugn order by the impugn judgment an award of rupees 12,84,000
12,97,84,136.
136 has been awarded in favor of the opposite party, which includes the interest component. During the pendency of FO, the parties have entered into settlement and they have agreed upon to settle the issue.
No, my lord, your lordship should not record the concession. Yeah, should not record the concession, my lord. Because the Justice Altra has passed that.
No, you have agreed.
No, that amicably we have settled it. But if the concession will be recorded, they will be put in trouble. That's the corporate client. Your lordship do nothing.
Direction
In that, your lordship direct that. As per your lordship's consideration.
Third line. The court is of the considered view that the compensation amount may be reduced to
modified to
consolidated amount of 10,50,000 rupees. 10,50,000.
Consolidated.
The counsel for the opposite party, Mr. So has agreed to the said reduction amount.
The counsel for the appellant left to the discussion.
Dispose of the amount you have already deposited.
Yes.
The entire about amount which has already been deposited before the for divisional labor commissioner. Divisional labor commissioner Cuttack.
Coram. Ganjam.
Full stop. The appellant may be
commissioner may be
refund for the
commissioner may be directed. Commissioner may be directed.
Let me.
Sorry.
If you interject, I will something else and you will be in trouble.
Sorry.
I understood it.
Yes.
The remaining amount, whatever it is, 1 lakh or something, you get along with interest, you will get it.
Yes.
Example is that side. The opposite parties, 10,50,000 rupees may be shall be disbursed to opposite party along with the accrued interest thereon, and the remaining amount lying deposited with the divisional labor commissioner Ganjam shall be refunded to the appellant along with the interest accrued thereon. With this term, this is it is needless to say that the appellant corporation, what is it?
Appellant
Insurance company has liberty to recover the amount from the owner of the vehicle. Respondent of 5 in accordance with the yes. Sorry. If recoverable. It is without prejudice, obviously.
That morning I made some 4 years inside because on the application of the conviction 10 years, 37 cases for the
Appeal. Bail.
Appeal bill the pending bill, charge to corporate. Written note be
To file objection.
Item 74.
Let it be there in the board. Let it be there in the board. I'll take it up tomorrow. Okay. Whatever remains, yes.